The first or second
नहीं काम उसको आते थे तो लंच के बाद जाने का नहीं शाम को ड्यूटी आपको भी सपोर्ट उसको और एक कलिका था उसको प्लानिंग करेंगे उसका प्लानिंग करके फिर शाम को जो काम करना का सब न्यू वर्क यहाँ पे तुम शाम को ड्यूटी के साथ यूज़र काम घर पर का सब न्यू काम
Leadership may mention one case from the list leadership at serial number 44 for contempt matter leadership, wherein the order of the Honorable Court has not been complied with despite leadership 7 months having been passed.
We take a notice a contempt matter. Contempt notice.
From date list this case item 48, second appeal 7 of 2008.
In this case, the appellant filed an objection under Order 21 Rule 97 CPC. The learned executive board without did not educate my objection and outrightly dismissed. Against which first appeal was also dismissed. Against which this second appeal has been filed. Lordship may kindly see order number 4. The substantial portion of law has been framed by this honorable court. Whether the trial court in
last time का याद नहीं है क्या observation?
हाँ?
They have filed an affidavit saying that it has become
No.
Your suit for specific performance has been dismissed.
Dismissed against
you
which
were claiming it on the basis of specific performance.
Performance.
Yes.
But Lordship may kindly see the substantial portion of law framed by this honorable court, Lordship, which is required to be adjudicated, Lordship.
Are you finally?
Yes.
Record which?
Yes, we have filed written notes of argument.
Where is it? This one. This is what you have said that this has become improper. Nothing on merit. You have nothing to say on merit. Who is your counsel?
Vishal. Actually, Milord, he is in 24 nights and just their information come.
Call him by the time he arrives. Yes, please.
Yes, Lordship, may kindly see order number 4, Lordship.
Where is what was the suit about?
The plaintiff filed eviction suit. Suit was decreed, Lordship.
Eviction suit on
Landowner tenant, Lordship. And suit has been decreed.
Just a moment. Suit number?
Eviction suit number 52 of 1994.
54 of 1994.
52, Lordship.
52 of 1994.
1994.
On ground of?
On the ground of, Lordship, default in making payment of rent, Lordship.
Default and any other ground?
No, Lordship.
Sure?
But Lordship,
Sure or not sure?
I am not sure, Lordship, because in order sheet, Lordship, it has not been mentioned, Lordship. Whether the default or personal necessity, Lordship, or lease, Lordship. It has been not mentioned, Lordship. May I read, Lord, the para 2?
No. Now you complete this chain. Suit was decreed. What happened to the appeal?
No appeal was filed by the tenant, Lordship. I am not the tenant, Lordship.
No appeal was filed by the tenant. Who was the tenant?
Tenant was, Lordship, Nagarmal Agarwal. One Nagarmal Agarwal was the tenant.
Alright, how are you related to Nagarmal Agarwal? Who are
Lordship,
you?
Lordship, after decree of the...
How are you related to
Lordship,
Nagarmal Agarwal?
I am coming, Lordship. I am coming, Lordship. Lordship, after decree, Lordship, the plaintiff filed execution case, Lordship, before the learned executing court, Lordship, and during the pendency of this case, Lordship, the plaintiff, Lordship, executed an agreement for sale of land, Lordship, to the present appellant, Lordship. And thereafter, Lordship, the present appellant
Yes,
filed.
sir. What is the date of agreement?
Date of agreement.
Plaintiff executed an agreement of sale
Agreement of sale, Lordship.
with the original.
To
With
the object, to the
object.
objector, Lordship. And appellant before this honorable court, Lordship.
What is the date?
Date of agreement is 21/3/2002, Lordship.
21/3/2002.
2002.
Okay. Saying what?
For sale of land, Lordship.
No, sir. That's right. What is the nature of agreement?
For sale of land.
For sale.
For sale of soap. It is a soap, Lordship.
Agreement for sale.
Agreement for sale of soap, Lordship.
Sale of consideration.
Consideration amount is 1 lakh rupees.
1 lakh.
So sorry.
How
No,
much?
25,000.
75,000, Lordship. The consideration amount was fixed 1 lakh and it was paid 75,000.
1 lakh. Paid 75,000.
Lordship.
And what was the period of agreement?
No, Lordship. It has not,
What was the time for executing the sale?
it has not been mentioned.
No time
It has not been mentioned.
in the agreement.
Agreement.
Agreement, alright, it has not been mentioned. After this, what happened?
Therefore, Lordship, the present appellant filed objection under order 21/97, Lordship, CPC for declaration of his right title interest, Lordship.
When you put in possession?
After decree, Lordship, the soap was handed over to the
Who handed over to you?
the plaintiff, Lordship.
So the tenant suo evicted
No, so tenant, Lordship, himself vacated.
when?
It has not been mentioned, Lordship.
So that's very important.
It has been not mentioned.
That's very important.
It has been
If you
not.
are in possession of the property, that is one thing. Where is your plaint? Where is your objection?
Plaintiff, Lordship.
Objection.
Objection.
इसका कोई रिकॉर्ड नहीं आया
For the agreement is concerned, I got the agreement copy, Lordship. No time has been mentioned, Lordship.
So according to you,
Ji.
when and how did you get the possession? Or were you in possession or you were not in possession?
I am still possession, Lordship.
How did you get the possession?
Lordship, after the judgment and decree, Lordship, the tenant, Lordship, vacated the land, the house, Lordship. Thereafter, Lordship, executed the agreement.
Therefore, the execution case had become infructuous.
No.
Yes.
During the pending.
If the tenant had already evicted the premises, then the execution.
I am not the tenant. I am
That's
the
right.
objector.
That's right. You are the objector.
Objector.
Yes.
During the pendency of the execution, Lordship, the tenant, Lordship, vacated the shop Lordship, thereafter
You
Lordship.
said that he vacated the shop and thereafter you entered into the agreement. And thereafter you filed the
No,
objection.
before Lordship file your objection.
When did you file your objection?
Lordship, I
What is the date of agreement?
Agreement is Lordship.
21/3/2002?
Yes.
What is the date of execution case?
Execution case Lordship.
Case number?
11 of 2001.
11 or 2000.
2001.
Right?
And agreement
Is 21/3/2000.
Agreement was 2002.
Agreement says, your agreement says that the tenant has already evicted. Your agreement on the face of it. It says that the tenant has already evicted. Now there is an agreement between the landlord, the original owner, and you have been put in court.
Yes.
If the tenant has already been evicted, then under such circumstances the execution had become infructuous, completely infructuous.
No. Lordship, the petitioner file objection, Lordship.
So why should the petitioner file objection?
Because there is a chance of the disposition, Lordship, thereafter they file.
Was any
objection.
notice issued to you?
No, suo moto appeared.
Suo moto you
Suo moto
filed.
appeared, Lordship. Suo moto appeared, Lordship.
Suo moto appeared, no notice issued to you, no steps
Because
taken.
I was not party in the execution case, Lordship.
Need not be, but suo moto you appeared without any notice, seeking your eviction, right? And then in the agreement itself it is mentioned that the tenant has already evicted and you are in possession of the property by virtue of an agreement entered into between the between you and
But the learned trial court Lordship has passed an order that there is no merit of it.
That's
He
right.
did not say that
We are looking at it.
he is the not the
We are
necessary
looking
party,
at it.
Lordship.
We are looking at it. We are looking at it.
He is the not necessary. There is no observation of the executing court.
Need
Lordship.
not be. When in second appeal, we will see your objection, we will see your agreement also, we will see everything.
Lordship, make
Apart from the improved order, we will see everything.
Yes.
So this is how the story is.
Lord.
That it was already evicted, you were handed over the possession by the landlord.
The eviction case was filed 2001
That's
and
right.
agreement is 2002.
2002, and before you entered into the agreement, the tenant had already evicted.
But there is a chance of disposition there of file objection, Lordship.
Nobody is proceeding. They say it has become infructuous. Do you want to proceed with the execution?
No, that's it.
They don't want to proceed with the execution. And as per your agreement, we can record that also. As per your agreement, you were put in possession by the original landlord. They are not interested in proceeding with the execution also.
Definitely because the tenant has vacated the
That's
premises.
right. That's right. So it has become infructuous for all practical
No
purposes.
infrastructure.
And your suit for specific performance on the basis of this agreement has already been discussed.
But the civil appeal is still pending before the learned district judge, Lordship.
Civil, that's right.
Civil
Let it
appeal
be met.
62
You
of
see,
2025.
just a moment. You are in possession,
Yes.
right? You are seeking remedy under the specific performance. The landlord has not filed any suit against you seeking eviction, right? So, and if they undertake that they do not want to pursue the execution case, the matter will be over. You should be happy with that.
But so far the substantial question of law is Lordship, given by this honorable court, it is required to be considered by this honorable court, Lordship.
But we will say that it is not required to be answered because they don't want to they don't want to proceed with the execution proceedings. Why should we answer a question which has become infructuous for all practical purposes, and given their undertaking that they do not want to pursue their execution proceedings at all? The execution proceeding will be closed. Simple. You will be happy. You are in possession. Enjoy your possession.
I am coming to merit of the case, Lordship. Para to Lordship, we can.
I will not decide it. You please appreciate. ये जबरदस्ती किस चीज के लिए? They do not want to proceed with the execution. The execution will be closed immediately. You are in possession by virtue of an agreement, and your suit for specific performance has been dismissed. You are in appeal, and you will have your remedies as per law.
Lordship, 1 minute, may I take instruction from my client has done Lordship, my chamber.
पूछिए आप उनसे इतना बहुत है.
Yes. I understood, Lordship.
Infructuous cases को ना इतना बोल देंगे. You are ready to not to pursue the execution.
Yes,
case.
obviously, Manoj, it has become infructuous.
May I take instruction,
हाँ,
Lordship?
पूछ गए. हर चीज कानून से भी चलता है,
जी।
थोड़ा कॉमन सेंस भी लगाइए।
जी नॉट सो ठीक बोल
इंफ्रक्चुअस केसेस को जबरदस्ती डिसाइड करने का कोई मतलब नहीं है। आइए पूछिए,
सेकंड केस हमारा ही
पूछिए, आइए ना दूसरा केस।
सेकंड केस को लॉट्स ऑफ क्लियर
नहीं, हम एडजर्न नहीं करेंगे।
सोमवार को
नहीं,
एक दिन मौजूद
नहीं करेंगे एडजर्न।
सब
दिखाइए ऑन रेस्पोंडेंट कौन सा।
Item 49.
आप जाइए,
379 of 2016.
रिकॉर्ड कीजिए। Who is for the respondent? Mr. Sani is there. Are you there, ma'am? Read there. What is the substantial question of law?
The substantial question of law is whether the learned court of appeal has misconstrued the provision contained in section 90 of Indian Coding Act, which lays down that if the document is more than 30 years old and has been reduced from the proper custody, the court may presume its genuineness and the findings of the learned court of appeal with regard to Exhibit 10 is perverse or not.
It is only a presumption of genuineness. It is not a conclusive proof, isn't it? It is a conclusion. Read the judgment. Let's see the type of judgment first.
The judgment is dated 31st of March 2016. This title appeal has been referred by the appellants and plaintiffs against the respondents, defendants.
No, not that. The tribunal.
This case has it's dated 3rd May of 2006. The judgment in this case has brought by the plaintiffs for declaration of their right and title over the land as mentioned in the schedule of the claim, and for declaration of sale deed number 1141 dated such and such and 1257 dated 25/5/96 as null and void and binding upon the plaintiffs and for order reviews.
Null and void and not binding. Isn't it?
And binding
Not binding.
not
Yes.
The plaintiff's case in brief, as stated by the plaintiff in the pleading, is that the plaintiffs and defendant number 3 are the descendants of a common ancestor, namely Choran Sahu, and Choran Sahu has two sons, namely Chutti Sahu and Vipat Sahu. After the death of Choran Sahu, his eldest son Chutti Sahu become the head and karta of the entire family, and both the brothers messing and cultivating jointly. Being the karta of the family, Chutti Sahu was looking after the management of the family affairs, and Vipat Sahu was looking after cultivating law. Further, case of the plaintiff is that being the karta of the family, Chutti Sahu purchased 8.14 acres of lands in an auction sale, including the suit land from the joint income fund and stock of the family, over which after purchased both the brothers came in cultivating in joint possession over the lands, and after mutation rent for the lands was paid jointly in the name of both the brothers. Chutti Sahu and Vipat Sahu amicably partitioned the ancestral lands according to legitimate share with the help of village punches, and Chutti Sahu also partitioned the auction purchase land. Vipat Sahu got 1.87 acres in the auction purchase land in partition with full satisfaction. On 23rd 5th 1963, a Sada deed of partition was also executed in presence of village punches, and since the
Bipad Sahu was coming in possession over the land measuring 1.87 acres, including the suit land, and after the death of Bipad Sahu present, plaintiffs were come in possession over the suit land. For the case of plaintiffs is that the plaintiff have also mutated for the lands including the suit land by mutation case number 55/8889, and against the said mutation, our Jageshwar Sahu and other son of Choti Sahu filed a mutation appeal number 15/8889, and after dismissal of the appeal, they agitated the matter before AC Gunda by filing an appeal being appeal number such and such, but all in vain. For the case of the plaintiffs, that the plaintiffs, including their father, Bipad Sahu, were and are coming in continuous uninterrupted possession openly and adversely to all concerned, including the defendants 3 to 6, and the defendant 3 to 6 have no concern in their title possession over the suit land. For the case of the plaintiffs, the defendants number 1 and 2 are practicing advocate, and defendant number 3 to 6 have executed 2 say deed, being deed number 1141 dated 14/5/96 and 1257 dated 25/5/1996 in favor of the defendants number 1 and 2 for the suit land. For the case plaintiffs, the 2 say deed, if remain unchallenged for many years, it may injure the interest of the plaintiff in future. Hence the necessity of the suit. It is also the case of plaintiff that 2 say deed have been executed within 15 days by the same persons in the favor of 2 brothers. Hence, to avoid multifariousness of the suit, the 2 say deeds are challenged by the suit. The cause of action for the suit arose on 14/5/1996 and 25/5/1996, the days on which the defendant number 3 to 6 executed of the 2 say deeds in favor of the defendant number 1 and 2 respectively. Within the pecuniary and territorial jurisdiction of the court, the plaintiff valued the suit at ₹14,000 only as the consideration money mentioned in the 2 say deeds, but the present suit is merely a declaratory suit, hence fixed court fees has already been paid by the plaintiffs. After registration and admission of the suit, all the defendants are summoned and receipt of the summon. All the defendants were appeared and contested the suit by filing written statement. In short, written statement in this case 5/2/1998, defendant number 1 and 2 has filed their WS, and the same day defendant number 3 to 6 has adopted the WS filed by the defendant number 1 and 2. The defendant's case in brief, as stated by the defendants in the pleadings, is that the suit is not maintainable in its present form, and the suit is barred by law of limitation, waiver, acquiescence, and estoppel. The suit is held by section 34 of the Specific Relief Act. Even the suit is grossly undervalued, the real value of the suit property is at least ₹25,000. The suit is not declaratory one, but the suit is for declaration of possession. Hence, the plaintiffs is bound to pay at ad valorem court fee. Even the plaintiffs have no cause of action for the suit. For the case of the defendants, that the suit is bad for non-joinder of necessary parties, as even heirs of Bipad Sahu and Choti Sahu have been made up as parties. Similarly, the brothers of Bhaktu Sahu are also the necessary parties of the suit. For the case of the defendants is that just after the RS operation, there has been an amicable partition between Choti Sahu and Bipad Sahu relating to their ancestral property, and they were separate in cultivation, separate dealings and transaction, and also separately enjoying the usufruct of the properties. There has been a complete partition between the brothers. Further case of the defendants that Choti Sahu has purchased 0.14 acres of lands in auction from his own income after the partition of the 2 brothers, and said, it's very weird in my judgment.
In auction from his own income
It is
after the partition of 2 brothers and said 8.14 acres, including the suit.
8.14 acres land, including the suit land, is the self-acquired properties of the Choti Sahu. Tutti Sahu remained in possession of the entire suit land, including others, till his death, and after his death, his sons and grandsons are in peaceful possession over the lands in suit, including others. Further case of the defendants that Tutti Sahu also sold several plots of land, sold it to different persons, and he never executed any sale deed or partition on 23/5/1963 in favor of Bipad Sahu, and Bipad Sahu never came in possession over the suit land. And if there is any such deed of partition, that will be forged as on 23/5/1963. Tutti Sahu was not present in the village. Further case of defendants that the defendant number 3 to 6 had every
So
right.
basically, with respect to the suit property, this Tutti Sahu and his descendants, they claim that was a self-acquired property and it was bought by their function, and they claim that it is a property purchased. But there was a partition subsequently after the purchase through auction. Correct? What were the issues?
So coming to the finding of the issue.
Roman 8 is the issue with which we are concerned. Partition in the year 1963. Correct? Exhibit 10 is 1963 partition.
May I read Roman 8?
Yes, Roman 8. That's what it is. Issue number 8. Read issue number 8.
In rebuttal, altogether 8 witnesses were examined
No,
on
in issue number 8 is at internal page 7. Sorry? The connected issue would be issue number 8.
Yes.
Right. Correct? Are you there in this case? Issue number 8 होगा सर. Para 11.
Para 11, issue number 8. In this context, it is the case of the plaintiffs that Tutti Sahu and Bipad Sahu, both the brothers, amicably partitioned their ancestral lands according to their legitimate share with the help village bunches, and Tutti Sahu also partitioned. The auction purchase land, Bipad Sahu got 1.87 acres in auction purchase land in partition with full satisfaction on 23/5/1963. A Sada deed of partition was also executed in presence of village bunches. In rebuttal, it is the case of the defendants that the partition between Tutti Sahu and Bipad Sahu were took place soon after the RS operation, and therefore Tutti Sahu has purchased some land by way of auction purchase, which is his self-acquired land, and Tutti Sahu never executed any Sada deed of partition in favor of Bipad Sahu, and the Sada deed of partition on 23/5/1963 is 4 documents. In this context, PW1, who is deed writer,
These are the discussions of the.
this
Just a minute. This is PW1. Right? PW1 has proved the same, that Sada deed, right? You read PW1. In this context, PW1, page 8.
In this context, PW1, who is a deed writer, proved the Sada deed of partition dated 25/3/1963. Said PW1 has deposed before the court that said deed was written by Akori Rajendra Prasad and it was written as per the instruction of Tutti Sahu, and all the witnesses, including Tutti Sahu, were also had their signatures in presence of him. But during the cross-examination, said witness clearly admitted before the court that name of the scriber that is invisible in the said date. Now, on perusal of the testimony of the said witnesses, it appears to me that
He's a man of 66 years.
it is not clear.
deposed before the court on 8/10/2000.
Before the court on 8/9/2000, that means at that time of execution of said deed, he was a man of 29 years and he claims that he was assistant of the scribe. PW2 in para 4 and 5 of his deposition has deposed that partition between Jyoti Sahu and Vipat Sahu were taken place in his presence, and on 23/5/1963, Jyoti Sahu has came to Gunda and executed of Sada partition deed in favor of his brother Vipat Sahu. Said witness also identify and prove the signature of Jyoti Sahu on the said deed. During the cross-examination, said witness clearly deposed in para 15 of his deposition that he is not the witness of Panchnama partition deed, even he does not know the date of execution of the said deed. PW4 in para 4 of his deposition also deposed that Jyoti Sahu has stated to him that he has executed a partition deed in favor of Vipat Sahu, and said partition deed was written by Rajendra Prasad. But during cross-examination, said witness clearly deposed that he is not the witness of the said deed, even he does not know on which date it was executed by Jyoti Sahu. PW6, one of the plaintiff in para 4 and 5 of his deposition, also fully support the pleadings of the plaintiff. Said witness further deposed in para 30 of his deposition that he has a clear mention in his claim that on 23/5/1963, Jyoti Sahu has came at Gunda court where he has executed a Sada partition deed on stamp paper and handed over it to his father. Plaintiff of this case also relied on the Exhibit 1, which has been marked as Exhibit 1 with objection, and on the basis of the prayer of the plaintiff, said deed 1, Exhibit 1 was sent to the handwriting expert for his opinion, and on 22/1/2003, handwriting expert has submitted his report, which was also upon marked exhibit on behalf of the defendant. And report of the handwriting expert clearly shows that the signature of the Exhibit 1 is not the signature of Jyoti Sahu. Even said handwriting expert was also examined before the court as DW5, and in his cross-examination, he said handwriting expert fully corroborates his report. On the other hand, all the material defendant's witnesses fully corroborates the case of the defendants even during the cross-examination. May I continue? Yes. DW1 in para 7 of his cross-examination clearly deposed that partition between Jyoti Sahu and Vipat Sahu was taking place in the year of 1938, and it was taking place 65-66 years back from the date of his deposition, and para 8 of his deposition shows that his house is situated 1 kilometer far from the suit land. DW2 in his cross-examination also support the case of defendant, though he is a man of different village. DW3 in his cross-examination also support the case of the defendant, but said witness also a man of different village. DW6 and DW8 are the party of the suit, and they also duly corroborated the case of defendant. During the argument,
These are the judgments relied upon. We will come to the bottom.
may I continue?
Yes, just really show that. Now considering the bottom.
Now considering the above said argument, for using the evidence available in the case report, it appears to me that though PW2 has claimed that Sada deed of partition was executed in his presence, but he did not put his signature on the said deed, though he was present at the time of partition. Even his testimony proves that it was not executed in his presence and was executed at Gunda, not in presence of the village panchayat. Even he does not know the date of execution of the said deed, PW4, who is one of the material witness of the plaintiff, clearly admits that said Sada deed of partition was not executed in his presence and it was not executed in the village. Even he does not know the date of its execution. It is also evident from the testimony of the said witness that he is the maternal uncle of the plaintiff. Hence, in my view, there is every possibility that he may be an interested witness. In this case, PW6 is one of the plaintiff, clearly been stated in his deposition that disputed deed of partition executed by Jyoti Sahu at Gurra not at the village, and it was handed over to Bipat Sahu. That means at the time of execution of the said deed, Bipat Sahu and village punches were not there. Moreover, it is the clear pleadings of the plaintiffs that the deed was executed in presence of the village punches, but he does not depose so, which clearly creates doubt on his testimony. Now, so far as purchase of land jointly by Chutu Sahu and Bipat Sahu are concerned in this context, in my view, purchase of lands jointly does not prove the jointness of the parties. Even two enemies can also purchase land jointly, and it proves the jointness of the purchaser. In that case, purchase of land in the name of single person shall be the proof for his separateness, but law cannot say so. It is also the pleadings of the plaintiffs that after purchase of the auction, purchased land, including the suit land, was mutated and rent was paid jointly in the name of both the brothers, but the plaintiffs of the case has failed to produce a single rent receipt in support of the above said pleadings, which also creates doubts on the said pleadings. Now, according to the plaintiffs, partition was taken place on 23rd Feb 1963, and the suit land was mutated in their name by mutation case number 55/1988-89. That is after the death of Chuti Sahu. So, why they were silent about the mutation during the lifetime of Chuti Sahu? The plaintiff just tried to prove with some rent receipt that after the dated 23/5/1963 Jamabandi was running in the name of Chutu Sahu and others means Chutu Sahu and Bipat Sahu, but they have failed to produce any mutation certificate or any register to prove that Jamabandi was running in the name of Chutu Sahu and Bipat Sahu. Soon after the alleged partition and all the conduct of plaintiffs clearly creates doubts on the pleadings of the plaintiff. Now, according to the para 6 of the plaint, on 23/5/1963, Sada deed of partition was executed in presence of village punches, but all the PWs, including the plaintiff, clearly deposed that it was not executed in the presence of village punches, even if it does not bear any signature of the punches. So, in my view, plaintiffs of this case fails to prove that it was executed in the presence of village punches. Even the plaintiffs fails to prove that when the meeting of the punches were taken place and said Sada deed of partition does not show that it was written as per the decision of the punches. Moreover, the plaintiffs had failed to give any explanation that why the
Ancestral land.
of ancestral land have not been shown in the said deed. Now the question is whether alleged Sada deed of partition was executed by Chuti Sahu or not. In this context, plaintiffs has failed to adduce a single witness who have witnessed the alleged deed, though according to the plaintiff's witness, all the witnesses of alleged deed, including the scriber, are no more in the world. But testimony of PW 1, 2 and 4 clearly creates doubts on the authenticity of the said deed. Moreover, on the prayer of the plaintiff's alleged signature of Chuti Sahu on the alleged deed along with specimen admitted signature were sent to the handwriting expert for his opinion, and opinion of the expert has been marked as Exhibit B2 on behalf of the defendant. Even handwriting expert Hari Narayan has also been examined as DW5 on behalf of the defendants. It is evident from the opinion of the handwriting expert that the disputed signature on the Exhibit 1 is not tallied with the specimen signature, and the disputed signature and specimen signature were written by two different persons. Now, in my view, when a witness is offered as an expert, three questions necessarily arises. One is the subject concerning which he is to testify, one upon which the opinion of an expert can be received. Second, what are the qualifications necessarily entitled to witness?
Where is the appellant? कहाँ गए वो? कितनी देर बात कर रहे हैं? जो दूसरा कोर्ट में चले गए? देख कर आए। Where is he? Where is he? मैडम ने आपका काम आसान कर दिया। ट्रायल कोर्ट का जजमेंट ऑलमोस्ट फुल टेक्स्ट में।
नहीं फर्स्ट केस का बोल रहे हैं कि उसमें पास ना हो His undertaking may be reported that he will not.
Where is he? बुलाइए ना. वो तो बोली रेडी थे.
हाँ रेडी थे, वही ऑर्डर कर दिया जेल से.
उनके प्रेजेंस में ही ऑर्डर कर दिया. तब तक आप इसको करें. नहीं.
नहीं बढ़िया
नहीं, नहीं.
नहीं पाएंगे.
कॉस्ट लगा के बिना नहीं करेंगे. 50,000 से कम का कॉस्ट नहीं है. आज के लिए फिक्स्ड है और आपके कहने में फिक्स्ड है. बहुत सिंपल. You see, we have read the judgment.
Yes.
What we have seen is
Yes.
that this particular document, which you say is 30 years old, apart from the oral evidences and everything, there is a presumption of 30 years old.
30 years.
There is no doubt about it.
Section 90 of the.
But the signature.
Handwriting
of
experts
yes.
say that.
Handwriting expert signature is
It
it is
differ-
only a presumption.
It is differ from the.
And it's a detailed order on that. Every witness has been examined.
I have gone.
So there is nothing in this case.
I have gone.
That I should pass the order.
My submission may be noted.
I will record this. देखिए ऐसे नंबर 379 of 2016.
एक जजमेंट देंगे सेक्शन 90 का प्रिजम्पशन का
Very
30 years old का.
Very. Madam, you read the judgment well. घर में तो पढ़ेंगे.
No, alright, sir.
मिस्टर सानी को बोलिए दूसरा कोट पढ़ा कर. What's your name?
Krishna Sadar.
ऐसे ही दिखाने के लिए
हाँ.
क्लाइंट को भी लगे कि बहस बहस.
नहीं, हम आपको पूरा बहस दिखाएंगे आपके.
पैरा 16 लो हम भी रात को पढ़े थे. मगर कुछ एग्जिबिट्स मेरे पास नहीं था तो हम देख नहीं पाएंगे. बस एग्जिबिट्स की कॉपी नहीं है. हम जल्दी प्रेयर करेंगे लॉर्ड से.
आपकी जगह हम देख लिए.
ठीक.
वैसे भी एक ही एग्जिबिट से कहानी है. हैंडराइटिंग एक्सपर्ट टैली हो
नहीं
गया.
इसमें कुछ एरर है. जो सब्सटेंशियल क्वेश्चन ऑफ लॉ 10 लिखा हुआ है एग्जिबिट 10 उसको 1
1
होगा.
राइट.
हाँ 1 होगा.
इसका पैरा 16.
पैरा 16 हम रात को पढ़े थे. हमको भी लगा कि कुछ है नहीं.
Essay number 379 of 2016 heard the learned counsels appearing on behalf of the parties. At the outset, both the counsels have jointly submitted that the substantial question of law framed by the order dated 25/9/2019, Exhibit 10 has been mentioned.
It should be
Instead, it should have been
1.
Exhibit 1. They submit that Exhibit 1 was the deed of partition
Deed of partition.
dated 23/5/1963, which was the bone of contention between the parties, and it was this document which was sought to be relied upon by the plaintiff.
Lords.
Check कर लीजिए please.
Agreement agreed in the one is the said deed लिखा हुआ है. It is a deed of partition.
दिखाइए सर.
In trial court judgment, Lords, internal page 6, Lords, it has been mentioned that that
that's
Sada deed of partition has been marked exhibit 1
Yes,
with
yes.
objection.
the said document was marked with objection. Accordingly, the substantial question of law framed in this case is accordingly, the substantial question of law framed by the order dated 25/9/2019 would be referable to Exhibit 1 and not Exhibit 10. This appeal has been filed against the judgment dated 31/3/2016 within bracket decree signed on 12/4/2016, passed by the District and Additional Sessions Judge 1 Gumla, whereby title appeal number 28 of 2006 has been dismissed. The prior to judgment was passed by judgment dated 3/5/2006 within bracket decree signed on 15/5/2006, passed by learned Additional Municipal Gumla in bracket suit number 33 of 1996. The suit was filed for declaration of right and title over the land mentioned in the schedule to the plaint, and for a declaration that SAD number 1141 dated 14/5/1996 and 12/1257 dated 25/5/1996 were null and void. This appeal was admitted for final hearing by the order dated 25/9/2019, and considering the submissions regarding the typographical error in the order dated 25/9/1919, the substantial question of law involved in the present case is as under. The learned counsel for the appellant has submitted that it is not in dispute that common ancestor of the part of the plaintiff and defendant number 3 to 6 was Churan Sahu, who had two sons, Chutti Sahu and Bipat Sahu. He submits that it was a specific case of the plaintiff that they remained in jointness and the partition had taken place in which the property purchased by Bipat Sahu were also included. The property purchased in auction
by the Chuttu Sahu.
by Chuttu Sahu. It was by Chuttu Sahu.
Chuttu Sahu.
You are representing Bipat Sahu.
No, Chuttu Sahu. Being the Karta of the family, Chuttu Sahu purchased 8.14 acres of land in an auction sale, including the suit land, from joint family income.
Okay. And ultimately, in partition, Bipat Sahu got 1.87 acres in the
Yes.
auction purchased land with full satisfaction. It was also the case of the plaintiff that on 23/5/1963, a Sada deed of partition was also executed in presence of the village panches. And since Bipat Sahu was coming in possession over the land measuring 1.87 acres, including the suit land, after death of Bipat Sahu, the plaintiffs came in possession over the suit land. Further case of the plaintiffs was that they got the property mutated by mutation case number 55 of 8889, against which sons of Chuttu Sahu had filed a mutation appeal. The appeal was dismissed, and therefore, thereafter, the suit was filed. It was a case of the plaintiffs, including their father Deepak Sahu, were in continuous and uninterrupted possession of the suit property, adversely to all concerned. The defendant number 1 and 2, who were the practicing advocates, the defendant number 3 to 6 executed say deed in favor of defendant number 1 and 2 by virtue of two say deeds, number 1141 dated 14/5/96 and 1257 dated 25/5/1996, with respect to the suit land. It was a case of the plaintiff that the defendant number 3 to 6 had no right, title and interest over the property, as by virtue of the partition, the land measuring 1.87 acres, including the suit land, was allocated to Deepak. Correct? On the other hand, it was the case of the defendant that the deed of partition was a forged and fabricated document, and it was never executed by Tuttu Sahu. Rather, Tuttu Sahu had purchased 8.14 acres of land in auction from his own income after the partition of the two brothers, and said 8.14 acres of land, including the suit land, was the self-acquired property of Tuttu Sahu, and Tuttu Sahu remained in possession of the property, and after his death, his sons and grandsons are in peaceful possession of the land in the suit. Considering the nature of substantial question of law, amongst various issues framed by the learned court, the issue number 8 would be relevant.
Yes. Findings is
Yes.
for I level.
The issue number 8 was decided against the plaintiff, and the learned first appellate court has also confirmed the finding. It is the argument of the learned counsel for the appellant that issue number 8 has been wrongly decided in view of the fact that there was presumption in connection with the correctness of Exhibit 1, which was of the year 1963, and this aspect of the matter has not been properly considered by the
It is presumed to be correct.
and the learned counsel submits that more than 30 years old document is
According to
presumed
section
to
90
be
90
correct according to section 90 of the Evidence Act. He has relied upon the judgment passed by this court reported in 2005 within bracket 4 JJR 18 and has referred to
Para 16.
para 16 thereof. To submit that once the document is produced from proper custody, there is a presumption in connection with correctness of more than 30 years old document. He submits that on the basis of legal principles, the Exhibit 1, if found to be genuine and valid, then the plaintiffs had a right, title and interest over the suit property, and therefore the sale deeds executed by defendant number 3 to 6 in favor of defendant number 1 and 2 was void ab initio. Correct. The learned counsel appearing on behalf of the respondents, Madam का नाम लिखी हुई है, पूरा नाम लिख के दीजिए.
पहला केस जीत रहे हैं. सेकंड
वो भी सेकंड.
वो भी सेकंड बहुत अच्छा बहस भी करते हैं. अच्छा बहस भी करते हैं.
सुने नहीं आप सुनेंगे.
मैं दूसरे कोर्ट में देखते हैं.
हमारे कोर्ट में नहीं करता. डर
पहली
लगता
बार
है
कर रहे हैं मैडम कर रहे हैं.
क्या? डर लगता है. Yes.
No,
She is very good
So
counsel.
it's a discredit to me. You get nervous in my court. If you are not comfortable in my court, it's a discredit to me.
Very much comfortable. Actually, even I've learned from observing from this court itself. I've learned a lot.
कोर्ट का पहला काम है सबको comfortable बनाना. At least to those who have read the brief. The learned counsel for the respondents, on the other hand, while opposing the prayer, has submitted that the signature of Chettu Sahu on Exhibit 1 was sent to handwriting expert for verification and comparison with the admitted signature placed on record. And the handwriting expert
Is DW5 who supported the case of the
DW5
who
he
supported
has
the
supported the
case of the defendant.
case of the defendant and had recorded a clear opinion that the signature did not tamper. The learned counsel has submitted that the 30 years old document has only presumption and the same has been duly rebutted by placing the materials on record. The learned counsel has submitted that detailed discussion has been made in connection with the evidence of the handwriting expert and also the oral witnesses which were produced. She submits that she submits that in spite of presumption of 30 years old document, the matter has been considered in right perspective by the learned court, and upon positive evidence placed on record that the signature did not tally, the presumption stood duly rebutted. She submits that under such circumstances, even if it is taken that there could be presumption with respect to 30 years old document, but on the facts and circumstances of the case and the evidences placed on record, the appeal is still fit to be dismissed. Okay? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the Exhibit 1, which is
Deed of partition.
which is a Sada deed of
Sada
partition,
deed of partition.
dated 23/5/1963, was placed on record by the plaintiffs, claiming that the suit property was subject matter of partition. And as per this document, the property fell in the share of Bipat Sahu to the extent of 1.87 acres. This was disputed by the defendants, and it was alleged that the Sada deed of partition was forged and manipulated. It was also stated that the property was purchased by Chettu Sahu from his own funds through auction in his own name, and the partition had taken place much earlier, immediately after the RS operations. The sheet anchor of the plaintiff was the deed of partition dated 23/5/1963. There is no doubt that the deed of partition dated 23/5/1963 was produced by the plaintiff and was from proper custody. But so far as the reliance on such document is concerned, it can be only taken as presumption regarding its correctness. It was certainly open to the defendant to rebut the presumption by needing positive evidence, and one of the most important evidences which have been placed on record is the opinion of handwriting expert
DW5.
DW5, whose evidence has been discussed at length by the learned trial court, to come to a finding that the disputed signature on Exhibit 1 did not tally with the specific specimen signature, and this became the prime reasons, apart from other circumstances placed on record, to hold that the deed of partition dated 23/5/1963 was not executed by TTC. This court is of the view that in spite of there being presumption with regard to genuineness of 30 years old document, the presumption was duly rebutted by the defendants and findings was recorded. In such circumstances, in such circumstances, this court is of the view that the learned courts have not committed any perversity in holding that the deed of partition dated, the Sada deed of partition dated 23/5/1963 was not a genuine document and not executed by TTC. Accordingly, the finding in connection with Exhibit 1 cannot be said to be perverse, in spite of it being more than 30 years old document. The substantial question of law as framed is accordingly answered against the appellant and in favor of the respondents. Consequently, this second appeal is hereby dismissed. हाँ, उसका कहाँ है वो? आपके एडवोकेट नहीं आए अभी तक। नंबर है उनका नाम फ्लैश कर देते।
इसके जूनियर बोली 24 नंबर में सर।
कोई बात नहीं, नाम फ्लैश करते। विशाल कुमार,
मिस्टर विशाल कुमार।
मिस्टर विशाल कुमार। It's what?
From supplemented is item 1, second April 73 of 1997.
Respondent, are you there?
Yes, appellant is a plaintiff for the court member. So plaintiff appellant. Plaintiff is defended suit for declaration right at it is proceeding A land. Suit was dismissed against the dismissal of suit. Plaintiff referred appeal also dismissed. And this second appeal has been permitted by this member. The substantial question of law obtained was on 5/5/98. The first
We have seen it.
Yesterday, I placed an executed document. The first substantial question law was the option for discrepancy in CS and RS record of records.
That's right.
The plaintiff name, the vendor of father of the plaintiff, loss was recorded in the survey of record of right law. It is Maglu Ghasi and Soma Ghasi. Plaintiff is claiming from Soma Ghasi. Now, so further discrepancy is CS record of right law. Exhibit D and Exhibit A law is different.
इनका केस जब डिस्पोजल करते हैं, this we have just started.
Yes.
लाइए थे the matter. You undertake not to proceed with the execution?
On the ground that they have
Yes, because the original tenant has already left. Second appeal number 7 of 2008. The learned counsel for the parties are present. This appeal has been admitted for final hearing by order dated 14/2/2008 on the following substantiation. The learned counsel for the appellant has submitted that at the stage of execution, an objection was filed by third party who was not a party in the execution proceedings. No, who was not a party in the suit.
Eviction suit.
In
Sorry
the
for
connected
interruption,
suit.
Lords. I have received instruction that the tenant, the heirs of the tenant is still residing in that property. Lords, may I be kindly permitted to narrate few things, Lords. Initially, there was an eviction suit which was being granted, and subsequently, Lords, what they happened, they have divided this entire thing into two parts. One part is the eviction suit, and second part this is the title suit with regard to the specific performance.
Then we have to hear it on merit.
No, Lords, my only submission that this particular order, which is the part of the title suit which has been decided on merits, that in itself is the interlocutory order of a title suit which has been decided.
This objection has to be treated like a suit.
Sorry, Lords.
Objection is required to be treated like a suit almost.
No,
My first appeal and second appeal lies therefore.
my only submission is, Lords, this order which is impugning this second appeal is an interlocutory order of a title suit, and that title suit itself is decided on merits, Lords. So my only submission that once a title suit is decided,
This is the interlocutory order of a title suit.
yes,
or
my Lords, this is.
It is the interlocutory order of an execution proceedings wherein the
No. But this is
objection
the
was
interlocutory order of the title suit 125/2006.
No, the eviction suit.
No, Zuram ji bata
Is
de.
it is arising out of execution case?
No, Lords, may I be kindly.
Let's see the para 1 itself.
Lords,
Mysterious case.
yes, Lords, may I kindly be permitted, Lords, to provide that. इनका सिनॉप्सिस में ये लिखे हुए हैं, Lords. वो जो नहीं इनका नरेशन जो है इसमें पॉइंट जो लिखे हैं, this particular this out of title suit, Lords, this is, Lords, may I kindly be permitted, few things may kindly be noted.
No, I don't know. You had filed a petition, it has become infructuous, right?
Lords, second appeal is being filed on their part on the ground of an order wherein the execution is required by the petitioner to be appellant to be stayed till the outcome of that title suit. That title suit has been decided in my favor, Lords. Now that itself goes. My only submission is to that extent, Lords. Once that title suit is decided, she said that two of the co-sharer has 2/3 of the share. See, with regard to the agreement to sale, she requires a specific performance, and meanwhile she says that until and unless this outcome of the title suit is being done, my possession may
Does
not
she
be.
claim that she is only in occupation of 2/3 of the share?
Yeah, Lords, she has provided agreement that their agreement is there. That is a specific performance. That, Lords, I have filed a supplementary affidavit. जिसमें मैं next claims point को kindly देख लिया जाए.
हाँ जो है ना इस तरह से ना अपने बातों को ना.
No, Lords.
Well, you can't.
Lords, my
You can't
only
behave in this manner.
no, Lords, my submission is that
Thrice you said that you have no problem, you don't want to proceed with
no,
this.
Lords, because I have received the instruction.
What instructions?
That-
You will make submissions without instructions.
No, Lords, my submission I have provided a may kindly be heard, Lords. My humble submission, Lords. May kindly.
We'll hear it first. You get ready for the. We are hearing it. We'll
No.
dispose it of today. What do you mean? We'll decide it today. चलिए पैसे.
क्लाइंट को इंस्ट्रक्शन लगी देंगे हमके.
कोई बात नहीं इंस्ट्रक्शन दे दिया आप इनका कहानी सुन रहे हैं ना. He is not ready to give an undertaking that they will not proceed against the execution. So
No, Lords, my only submission this may kindly be recorded that this
आपके कहने से नहीं रिकॉर्ड करेंगे.
Lords, my submission it may be accepted.
What submission? You will have your turn when you will have to make
Yes,
submissions.
Lord.
We'll see what is to be
ठीक,
done by
ठीक,
you. You don't know what you are submitting before the court.
No, Lords, the
Without
reason-
instructions, you make submissions, and then your client will come and stand at the head at my head.
No,
to give you instructions.
No, it cannot happen.
Yes, this is what has happened.
No, Lords, no, that
This
is
is
not.
what has happened.
Lords,
He
my
stood right there.
sorry, Lords, I have a different vote. That if he has done
No, he
that,
was-
I'm
he
very
was
sorry.
standing right here.
I'm very sorry for that, Lords. I'm very sorry for that. If he is here, then I'm very sorry. This is not the proper way.
हाँ चलो बताइए.
Lords, may can see para 2 of the amended first appellate court, Lords.
Yes, yes.
The case of the applicant is sought that the soap premises measuring more or less so and so, being the portion of the soap from residential holding number 6, Golmuri Market, is in possession of the applicant. The said soap was previously in occupation of one Nagarmal, who happened to be the tenant of the OP respondent number 1 to 3 and Srimati Maya Rani Sarkar and Hansi Nag Sarkar, and they all brought in eviction suit number 52 of 1994 against their tenant for his eviction said ultimately decreed in favor. Thereafter, the judgment holder brought execution
Just
case
a
number.
moment.
यहाँ तो एक eviction suit के बारे में बोल रहे हैं, टाइटल सूट बोल रहे हैं.
कोई बात नहीं, उनको खुद ही नहीं पता है क्या बोलना है।
लॉजिक में आगे इसको देखते हैं.
Yes. Eviction suit number 52 of 1994 against their tenant for eviction and said should ultimately decreed in their favor. Thereafter, the judgment order brought as execution case number 11 of 2001 for execution of decree passed in the said eviction suit, and later that said tenant handed over the vacant possession of the said shop and his landlord, that is Maya Rani Sarkar and Hansi Nag Sarkar, and in token of said delivery, they both the granted receipt. The further case of the applicant is that later Srimati Maya Rani Sarkar and Hansi Nag Sarkar, being co-owner of the said shop, enter into an agreement for sale on 21/3/2003 with the husband of the applicant, that is Sanjay Kumar Gupta, for total consideration amount of rupees 1 lakh and a sum of rupees 75,000 was paid as an earnest money, and possession of the said shop was given to the husband of the applicant on 21/3/2002. Since then, he is running his business and taking advantage of the pendency of the execution case. The opposite party, knowing the manner of the occupation over the suit in question, mysteriously pursuing the said execution case with oblique motive to dispossess the applicant from the soap in question, earn a huge amount, violating out the same in some money. To be expected a person miscellaneous case, the respondent, without receiving any notice whatsoever from the court of the Munsif, suo motu appeared and filed so called. And court below, after hearing the parties in the matter concerned, dismissed the case of the applicant since this appeal. The respondent appeared in the court below and raised objection by way of filing objection petition rejoined, wherein apart from the denying the claim of the applicant, they took the stand that as per the applicant on case till today only an agreement for sale is in existence, and two executed only two co-owners and suit bearing the title suit number 125, which had filed on the basis of alleged agreement for sale dated 21/3/2002 for a specific purpose of conduct is still pending for disposal. It was also stated the applicant with dishonest and malafide intention suppressed the said material fact while filing the miscellaneous case. She cannot claim any interest. No legal right can be accrued till her suit for a specific purpose of contract is decreed in her favor. It is also their assertion that in fact the applicant has been set up by judgment debtor to delay the disposal of the execution that has already been lost of the appeal. An objection which was raised in the execution case number 40 under section 47 of CPC was also rejected. During the argument, it has been contended on behalf of the applicant when the applicant had claimed her independent right at an interest over the suits of the court below should have taken advances oral in the commentary of the party and should not have dismissed the case at the admission stage itself. Further, it has been contended that finding of the court below the applicant cannot claim any interest in the decretal so till her suit for a specific purpose in contract with decree is now in erroneous. Contention has also been raised that irrespective of the pendency of the said suit, the applicant could have very well raised objection and asked the court to adjudicate upon her independent right and interest over the decretal swap in the said pending execution case itself. It was necessary for the court to make inquiries and come to final decision. As it is evident, the case of the applicant is that when the suit was decreed and the execution case was pending, the tenant's judgment that vacated the suit for and the two co-owners of said suit enter into an agreement with her for sale of the same soap, and pursuant to that they handed over the possession of the said suit to her, and since then she is possession of the same. It is also her case that in view of all those developments, she has her independent right and interest in the sense of whereas the respondent stand is that applicant has no any right to interest in the suit at all, and C in fact has been set up by the judgment data just in order to make the further delay in execution of the decree passed by the court below. Not only the appeal, which was preferred because the Honorable Court against the state judgment and decree has been dismissed by the objection under Section 47 of the CBC before the Executive Court has also been rejected. It is also their case that there is no occasion for the applicant to enter into the agreement for sale with the co-owner, and though this material fact has been conveniently suppressed in miscellaneous case filed in the court below. Now it is admitted fact that she has already filed a suit for specific performance of contempt on the basis of the said agreement dated 21/3/2002 has prayed for a direction to begin to execute and register the sale in her favor in the state of stop imposter. Therefore, it is apparent from the stand taken by the parties that moot question involved in the instant case whether the appellant can be taken to have any independent right title interest in the suit or not when the claim is based on the agreement for sale, and still there is no decree passed in her favor in the suit which she has filed for the specific purpose of contract on the basis of the sale agreement. It is settled principle that to resist the decree in any execution case by filing under Order 21 CPC, the third party is to he or she has independent subsisting right title interest of his or her own in respect of the critical. But it is also settled principle that the agreement to sell creates only a right to consumer but does not create any right in the property. Such agreement to sell only gives the right to the proposed procedure to bring a suit for a specific purpose of contract, seeking direction for the court to the defendant to execute the sale in his favor. And so long the said suit is not decreed in his favor, no right title interest accrue to him. He cannot claim any interest in the said property. In this connection, there is something appearing for the respondent refer the decision repeated in so and so para 9. Therefore, it is become apparent from whatever that has been held in the apostle decision of the Honorable Court, a person whose claim is based on the agreement for sale cannot reasonably claim any interest or legal right in the property in dispute, and no right and interest can be taken to have accrued such person unless the decision is made in favor in the apostle nature of suit. Consequently, in the instance that the appellant cannot be taken to have any prima facie case in her favor regarding any right having interest in the decree. In terms of Section 12 of the BBC Act, decree passed has certainly binding effect on the applicant also claimed to be residing in the decree. He cannot get hold over the state so only if the succeeds in the apostle suit filed by her. As it is apparent the decree passed in the eviction suit of the year 1992 could not be executed so far due to reason that judgment that held all the possible forms in order to abide the said decree. When the appeal was dismissed, no objection petition was rejected. Then the present applicant came forward claiming her own independent right and interest in the said decree. So, in contention raised at this stage on behalf of the respondents that simply it is yet another attempt on the part of the judgment debtor to avoid the decree and to delay its execution for as long as possible. And the appellate is none other than the person set up by judgment debtor to receive this aid. Thus, in view of the decision made above, it is very well concluded that finding not even the prima facie right of the interest of the applicant in the decree. So, the court below has rightly dismissed the said misleading case as the admission state itself, and the order passed needs no interpretation.
You just tell us one thing. You have already filed a suit prior to filing the miscellaneous case. That suit was already pending.
Suit was not dismissed. Now suit was dismissed
Now
against
suit has been dismissed.
civil appeal number 62 of 2020 filed before the London District Court.
So now, as of now, which has been placed on record, that the suit for specific performance has already been dismissed. So therefore, under such circumstances, you have to pursue your suit only. Otherwise, what right do you have? So far as this particular execution case is concerned, they have dismissed it by saying, now, if the court proceeds to decide your independent title in this, there will be a conflicting decree. There will be a conflicting decree, and in your miscellaneous application, you did not disclose that you have already filed a suit for specific performance. So that is not permissible in law. You see, this particular eviction. Suppose whenever the eviction proceeds and if they still proceed to go for the execution, then on the spot, if they say that the legal heirs of the original tenant is residing, if on the spot they are not found, then under such circumstances, your right will be proceeded. That will be taken care of as per law. You have already lost the this suit for specific purpose.
But appeal is pending.
Appeal is pending.
Appeal is pending. Lord.
Appeal is pending.
Appeal is pending. But law is said that you can say order 21.
Then under such circumstances,
CPC. Mechanism order 21/97. May resistance or obstruction to possession of the immovable property, where the holder of the decree for possession of the immovable property or the purchaser of any such property sold in execution of the decree in resistance or obstructed by any person obtaining possession of property, he may make an application to court complaining the said resistance or obstruction. Where any application is made under sub rule 1, the court shall proceed to adjudicate. This is very important also. Upon the application in accordance with the provision herein contained. Now, Lord, say rule 101 also. Question to be determined. All questions, including the question relating to right title interest in the property arising between the parties to a proceeding on the application under Rule 97 or Rule 99 with their representatives, or relevant to the adjudication of the application, shall be determined by the court dealing with the application, not by the separate suit. And for this purpose, the court shall
and not by a separate suit. You have already instituted a separate suit. Had you informed the court at the threshold that you have already instituted a separate suit for your right title interest with respect to the property, the court would not have entertained it. There is a likelihood of having parallel degree. Suppose you win before the executing court, your miscellaneous application is allowed. What will happen? Conflicting degree. Isn't it?
Okay. I am relying the subject matter already supplied to the Ministry. We can see 2002, 7 SSC, page 50, relevant paragraph 50.
2002 7 SCC.
Page 50, Lord, see. The relevant paragraph is 50, Lord.
Para?
Para 50, Lord. To find that in case in hand the appellant is claiming its independent right over the property in research its position
No.
there.
Para 15 is not tallying. The submissions of the learned counsel for now.
2002 7 SCC page 50.
Page 5. Page para 15.
Para 50 words. we find that in case in hand the applicant is claiming its independent right over the property in assets, its possession thereof. Order 21, Rule 1 clearly provides all the questions relating to right title or interest in the property relevant to adjudication of the application shall be dealt with the application not by the separate court. The High Court therefore erred in refusing to hear the appellant on the ground that it has already filed a suit for declaration of title for declaration that decree passed in title suit is not binding. In this case, also separate suit was filed.
No. In this case, a separate suit was filed and
Yes.
the decree which was under execution was not binding.
Not binding, but suit.
But you have an independent suit completely. You have an independent suit regarding specific
Performance of
completely
contract.
independent suit.
But the objection filed for declaration is right title interest before the learned executing court, which is required to be adjudicated. This is my submission.
How your right title and interest?
On the basis of the agreement, Lord, because I am the possession of the land, I am still therefore a stay was granted by this honorable court, Lord. I am still possession of the land. Therefore, there is a stay in my favor, Lord.
On the basis of agreement, you are in possession.
Yes. And therefore, Lord, a stay has been granted by this honorable court.
Can you protect your possession under 53A?
53A, correct. Absolutely correct.
What is the date of agreement?
Date of
53A, Transfer Property Act.
Date of agreement is not 21/3/2002.
And any plea under 53A can be taken only when agreement is registered with effect from 2001. Is it a registered agreement?
No, it is unregistered
It's
agreement.
absolutely.
It is unregistered.
So
Agreement
you are not entitled to protection under section 53A also.
But agreement of sale is not required to be registered, Lord.
No, 53. If you want to take protection of 53A, then it has to be registered. For specific performance of contract, it need not be there. ये सब हमको मत सुनाइए.
नहीं.
ये सब पता है ना आपको जबरदस्ती वाला ये सब ऐसा.
And
53A amendment, there has been an amendment in 2001
That's
that in
what-
order to claim protection of 53A,
Agreement is
it has
required.
to be registered.
Required to be registered. Next judgment process. 2022-151, Allahabad 634, para 11 and 35.
(2020)
2022, volume 151, Allahabad.
para number 11.
11 and 35 also. And 35 also may be seen. The review of the above, it is incumbent upon the executing court to decide if they adjudicate the application objection of the petition paper under order 21/97/19 CPC to find out the nature of the right of the petitioner over the disputed property. Thus, the execution court committed error in rejecting the application of its objection under section 97/99/101 of 20 CPC note 19. And second judgment. 2015, 1 SSC page 37. Samir Singh case. Para 20 and 21. At this juncture, we may refer with profit to the pronouncement in Brahmdev Chaudhary versus Rishika Prasad Jaiswal and another year 1982, wherein the two judge bench spanning the anatomy of the rules came to hold that a stranger of the decree who claims an independent right title interest in the decreed property can offer his resistance from the getting the actual discovery. He can equally agitate his grievance and claim of the adjudication with an independent right title interest in the decreed property even after losing the possession as per Order 21, Rule 99, Order 21, Rule 9 deals with a stage which prior to the actual execution of the decree where the grievance of the obstructionist can be adjudicated upon before the actual delivery was done to the decree holder. and the another judgment.
Just tell us one thing. So far as the executing court is concerned, they did not adjudicate it at all. There was no adjudication.
No adjudication.
There was no adjudication.
No adjudication.
Let us see the judgment of the executing court.
Yes. No issue was framed, no evidence was.
But it was not even admitted.
No, it was
Not
not admitted. Order dated 13/8/2007, Lordship. The lowest attendance has been filed in behalf of both the parties. This order disposed of this miscellaneous case number 9 of 2007.
Yes, respondent.
My Lordship.
In a case where there is a decree under BBC Act asking the tenant to evict. Now a third person comes and says that I am in possession of a property by virtue of an agreement of sale. I am claiming independent title over the property. Now she has also filed a suit for specific performance of contract. And if the landlord ultimately wins the specific performance of contract case, as in your case also, you have already won it. So in order to recover the property, will you not have to take a separate proceeding? Or you will get him evicted only by this proceeding?
No, we have to
So
find.
therefore, whatever is the nature of possession,
My lord.
whatever be her nature of right, all that has to be adjudicated.
Definitely that has to be educated, but that has to be educated in the way of execution proceeding.
That's right.
So my only submission is, Lord,
In execution proceeding, only they have filed this petition. The entire second appeal is arising out of execution proceedings, wherein a petition was filed and which was numbered as a miscellaneous case, against which the appeal has been dismissed. The executing court refused to decide, even admit the case. So that independent title has to be gone into, whatever be the nature of title.
the basic of the entire dispute is whether there is an agreement, and that agreement is with regard to specific performance. There
You
is
see, we are not here to decide the merits,
no that
because the courts have not decided the merits. Courts have not decided the merits. We are not here to decide the merits of the case.
if we are confining only with regard to the imperial order in the second appeal,
Yes.
that is somehow has become infructuous on the ground that the title suit has been decided in my favor.
Not necessarily.
Reason being,
Not necessarily, because on the spot you will not be able to evict them by treating them as tenant. Because they are not tenants. As per their case, they have not been put in possession by the tenant.
yes,
They have been put in possession by you,
my lord, that
independent of that
my
ex-tenant.
lord, my submission is in that agreement. It is not nowhere in the part that we have provided the possession, my lord.
It is there. Have you read the
My lord,
agreement?
my submission, this Kusum Kumari Gupta is the only person who is deciding.
That, you see, we are in second appeal.
My lord,
The matter has not been adjudicated. What is the nature of agreement? What is the nature of possession? Whether that possession can be protected, not protected. Having that agreement having come into force after 2001, it is an unregistered agreement. They cannot have 53A protection. These are just indicating the contours of law, right? But we are not here to decide that question.
that is there.
Therefore, the case was to be decided on merits.
Reason being, not
बताइए।
once.
आप बताइए, एक्सपीडाइट हम कर देंगे, जितना तेजी से बोलेंगे, दोनों पार्टी को एप्लीकेट करके एक्सपीडाइट, but this order cannot sustain. They are claiming an independent title, completely independent title. And you,
She is claiming
and you
that.
just see what are you doing
My lord,
in a suit where execution is proceeding out of a tenancy agreement. You are trying to evict a person who is in part performance of contract as per their agreement.
yes.
And handed over possession by you. Correct? So, एक तीर से दो सिक्का.
No.
हाँ वही
नहीं, ये नहीं है.
समझ में आ गया.
नहीं हुजूर ये नहीं है.
वही समझ
This
रहा
is
है.
what they are doing, my lords. This is
So,
not
yeah.
our part, my lords. My only submission is once this their dispute with regard to the specific performance that has been decided in my favor, my lords. And once that eviction suit is also been decided in my
You
favor.
see, even if that is decided in your favor,
Both the suits are
both the suits are
yes, my
decided
lords.
in your
Yes,
favor.
yes.
But in order to recover the possession of the property, you have to file a separate suit against him
Recovery of
for recovery of possession.
Not
Yes.
recovery of possession can only be done if there is a cause of action against me. Once that
No,
court, that
no,
the,
you
no, no.
have a call. I
My
don't
lords,
know. You
no, no,
don't
my lords,
understand
my
the cause of
lords, the
action.
reason being
You have put them in possession, right? And ultimately, the suit
the
was
court has
specific.
decided against them, my lords.
So
The court has
so
decided
that's
against
right. But there is no order asking them to give you possession.
them. My lords,
For
once he is saying that my lords, if I have a title with regard to a particular piece of property, then I have to provide that I have a title. I have to prove that. She
No,
has, my lords, she is saying that there is an agreement to that.
The moment there is a specific performance of contract,
Yes, my lords.
right? Your
See-
title is not in dispute.
No, no, my title is not in dispute. I am telling with regard to the appellant, my lord. She is saying that I am having 2/3 of the share by virtue of a specific agreement to sale, my lord. And that is there. She is seeking specific
We are
performance.
not here to decide on the merits.
I am not saying that, my
So
lord.
you,
I am not just
whatever
making a
argument
submission.
you have to make, you have to make it before the learned executing court.
That is there, my lord.
So go and make it.
Yes, तो
So it has to be decided.
हाँ हाँ ठीक है उस point पे.
देखिए, essay number 7 of 2008. Heard the learned counsel appealing on behalf of the parties. This appeal has been filed against the judgment and order dated 20/12/2017 passed by learned District Judge East Singhu dismissing the miscellaneous appeal number 31 of 2007 and confirming the order dated 13/8/2007 passed by the learned Munsif Jamshedpur, whereby miscellaneous case number 9 of 2007 has been dismissed. The records reveal that the miscellaneous case was instituted in execution case number 11 of 2001, which in turn was arising out of eviction suit number 52 of 1994. The eviction suit was filed against the tenant who was evicted on account of default in payment of rent. The judgment in the eviction suit became final. And at the stage of execution of the case, the applicant had filed a petition under Order 21/97 of CPC, claiming that he was put in possession of the property by the owner, within bracket landlord, by virtue of agreement of sale dated 21/3/2002, whose total consideration amount was rupees 1 lakh and an amount of rupees 75,000 was already paid. However, at the time of filing the objection under Order 21/97, the applicant did not disclose that she had already filed a suit for specific performance of contract, being title suit number 125 of 2006. This fact was brought to the notice of the court by the landlord, who responded to the petition filed under Order 21.09.2025 CPC. And ultimately, the miscellaneous case number 9 of 2007, which was a petition, under Order 21.97 of CPC, was not admitted and was dismissed. The learned counsel for the appellant has submitted that it was the specific case of the applicant that her possession over the suit property was based on agreement of sale. आप लोग ध्यान दीजिए प्लीज, काउंसिल्स एरर हो जाएगा, ध्यान दीजिए, इतना गप करने का नहीं है। और जिसके फेवर में ऑर्डर कर रहे हैं उसको ज्यादा ध्यान देना चाहिए। एरर होगा तो 1 मिनट में ऑर्डर हो जाएगा। The learned counsel for the appellant has submitted that the applicant was claiming an independent
Right
title and interest over the property by
on the
virtue of
basis of the
agreement of
agreement.
sale dated 21/3/2002, and the same was required to be adjudicated. He submits that when she was claiming independent title and not through the tenant, her right was certainly required to be adjudicated, and the learned executing court erred in not admitting the case. He also submits that this aspect of the matter has not been properly considered by the learned first appellate court also, and therefore the approach is substantial of law has been treated. ऊपर ही देंगे substantial. The learned counsel submits that he is not seeking any adjudication by this court on merits, but the matter having not been admitted by the executing court is required to be adjudicated by the executing court, and the impugn orders be set aside after answering the substantial question of law, and the executing court be directed to adjudicate the claim of the appellant. He has also submitted that that is enough.
Yes.
He has relied upon the 3 judgments. Relied upon the judgment passed by Honorable Supreme Court, reported in 2002 bracket close 7 SCC 50, paragraph 15. Then bracket 2015 bracket close 1 SCC 379, para 20 and 21, and also a judgment passed by Honorable Allahabad High Court reported in 2022 Supreme within bracket ALL bracket close 116 para 11 and 35. ये सारा कोट कर देंगे इसमें।
एक अपना हाई कोर्ट का भी है।
अपना हाई कोर्ट का कौन सा?
हाँ इसी।
And also CLP number 511 of 2025. तो para
3 का इसको मार्क किए हैं नोट।
decided on 2/7/2025, which in turn had relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2015 bracket close 1 SCC 379.
समीर सिंह वाले जो पहले हैं।
Assamese. इसका पैरा 25 and 26.
मगर हम जो पद दिए हैं जो समीर सिंह है वो पारा 20 या 21
25, 26 में तो देना होगा ना।
हाँ जी।
ये जो समीर सिंह वाला जजमेंट है इसमें 25, 26 में डाल देंगे।
नहीं उसमें 20 and 21 है हम जो दिए हैं
अच्छा उसमें 20
and 21 है इनका जजमेंट जो दिया तो 25 and 26 था
साइटेशन से
जी।
The learned counsel for the respondents on the other hand has vehemently opposed the pair and has submitted that the suit filed by the appellant seeking specific performance of contract has already been dismissed, and therefore there is no need for any adjudication now. They have submitted that the present case has become infructuous and no useful purpose will be served by remitting the matter to the executive court to adjudicate the case, to adjudicate the independent title of the appellant. In response, the learned counsel for the appellant has submitted that an appeal has been filed against the judgment passed by the trial court rejecting the plea of specific performance of contract. The learned counsel has also submitted that in case the appeal is pending and the same proceeding has not yet attained finality. The learned counsel has also submitted that in second appeal, this court is required to only answer the substantial question of law as framed, and appropriate order with regard to the nature of possession, etc., has to be passed by the executing court. Had the executing court admitted the miscellaneous application. After hearing the learned counsel for the parties and upon going through the improved judgments and considering the nature of substantial question of law as framed, this court is of the considered view that the appellant was seeking adjudication of her female hai,
right title
her independent right in connection with the property, which was and she claimed that she was in possession of the property, she was put in possession of the property directly by the owner of the property, who was the landlord, in the eviction suit number 52 of 1994, which was filed against a tenant, if other than the
Appellant.
appellant. However, the learned executing court refused to adjudicate, refused to admit the case and adjudicate the claim of the appellant. The learned first appellate court has also dismissed the appeal this court is of the view that in view of the aforesaid judgments cited by the learned counsel for the appellant, this court is of the considered view that the objection filed by the appellant before the executive court claiming independent right was required to be adjudicated, and the case could not have the learned executive court erred in law in refusing to admit the case, and the learned first appellate court also erred in upholding the order of the executive court. Accordingly, the substantial question of law as been by order dated 14/2/2008 is decided in favor of the appellant and against the respondent. The improved judgments are hereby set aside and the matter is remitted to the learned executive court to decide the objection filed by the appellant under Order 21/2/97 in accordance with law. At this, the learned counsel for the considering the fact that there are counsel for the parties are directed to appear before the executive court. I give a fixed date for appearance at 11 a.m. The matter is, the execution case is of the year 2001. The parties to cooperate and the learned executive court shall take all steps to decide the case as expeditiously as possible.
Supplementing is Second 73 of 1997.
So to satisfying the substantial question of law in favor of the appellate lawsuit, so there is a first substantial question of law. Whether in case of discrepancy between the entries in CS and RS record of right, the entry in RS record of right will prevail now. And the name of the vendor of the plaintiff lawsuit, they already in the RS record of right, and they are claiming only on the basis of CS record of right. That only Magnu Hasid's name was there in the CS record of right. And there is
CS record of right is exhibit number.
exhibit, that was exhibit as D and D by 1.
CS record.
CS record of right.
They are claiming only on the basis of CS record.
CS record of right. And the
You
exhibit.
had submitted yesterday that in the written statement they have not referred to any record of right. In the yesterday your
Yes,
submission was
they have not mentioned in the written statement.
there. The please.
Can you see the written statement also? May I permit to read the
Yes.
written statement? Paragraph that the present suit is in its present form is not maintained and is liable to be dismissed. That the suit is barred by law, limitation, waiver, and notice. That the suit is barred in non-tender and misjoinder of the parties. That the plaintiffs have no sense, no cause of action as stated in paragraph 14 of the plaint. The suit is also defective in multifarious of cause of sections. That the suit is the undervalue. 6. Para 1 of the plaint. That the statement made in para 1 of the
आपको
plaint.
जो प्लेन मिला है ना अनअमेंडेड प्लेन दिस इज नॉट करेक्ट दिखाइए ये नहीं होगा ना आपके पास
ये मेरे पास नहीं है, ये ऑर्डर शीट में भी नहीं, जजमेंट में भी नहीं आया हुआ
कोई बात नहीं
Yes.
लेकिन है
हाँ ये रीडिंग आ गई
राइट
यस
इसलिए प्लेन रिटन स्टेटमेंट बिना देखे हम कोई केस डिसाइड नहीं करेंगे
यस क्योंकि जजमेंट में भी कहीं पर भी ये
कोई बात नहीं इट्स नॉट योर मिस्टेक आई एम जस्ट इंडिकेटिंग
Yes.
दैट सबमिशन वो ऑर्डर अभी तक अपलोड नहीं हुआ है शुड आई डिलीट दैट सबमिशन फ्रॉम देयर
यस
हां
Yes.
ये तो देख लिया ना
यस
I don't think that it has been uploaded. कल ही का तो ऑर्डर है ये.
यस करेक्ट
Let me just correct it. I am deleting the learned counsel has submitted that there was no foundational pleading on the part of the defendants with regard to entry in CS record.
So far as the discrepancy is concerned, Lordship, kindly see Exhibit D and Exhibit A, Lordship, which is contrary to each other, Lordship. Exhibit A, they are claiming, Lordship, Jamindari rent receipt, Lordship, issued by one
No,
Maharana.
we will come to that.
Yes.
Let us see the findings of the learned trial court and the appellate court.
Yes.
How they have discussed Exhibit D and D/1 and Exhibit A. 3 documents would be relevant according to you.
So far as substance question of first substance question of discrepancy is concerned, Lordship, Exhibit A and Exhibit D is contrary to each other, Lordship, and so far as substance question of law, second law is, Lordship, and perfected my right at an interest, Lordship, on the basis of Exhibit 1, 3, 5 and 6, Lordship.
You are claiming adverse possession.
No, Lordship, I purchased the land, Lordship.
You are the purchaser.
I am purchaser, Lordship, by through registered sale deed, Lordship. In the year 1987, Lordship, that is Exhibit 1, Lordship. And thereafter I
It's- Exhibit A does not match with Exhibit D.
Exhibit D and D by 1.
Match. Exhibit
D by 1.
D
D and D by
which are CS record.
CS record of it.
CS record. Exhibit A is the rent receipts.
Jamindari rent receipt.
Issued that.
Issued by landlord Maharaj Pratap Sharde. Exhibit A.
For village,
For village, Exhibit A is considered the village Jarda, Lordship.
Jarda, Z A R D A.
Z-A-R-D-A. And Exhibit D
This
and
is who is the landlord?
landlord name is Maharaj Pratap Sharde.
No. Exhibit D and D by 1.
D by 1 में है शेख बहादुर अली.
Bahadur Ali.
और इसमें
It is in connection with
विलेज मौजा बरवे.
village Barbe.
बरवे.
B-E-R-B-E. Okay. Otherwise, the description of property is the same. Otherwise, the
Inspection. Although I didn't get the copy, but I have in the lunch hour yesterday, I noted down everything from the original record. Without wasting time, if your lordship may permit me to refer to Exhibit D. Exhibit D, Exhibit D, what my learned friend is saying, moja is different. Your Lordship will find on the top of the khatiyan there are three things, three columns. First column, the district. Second column, Pargana, and third column is village. And three names, ऊपर नीचे थोड़ा लिखा गया है. Pargana is going to be another and village name is Jarda. So my learned friend is referring.
Pargana is Barbe.
Barbe, yes.
ये मौजा
You will have to just see for a moment if I am not wrong. Exhibit D.
एग्जिबिट डी एंड डी बाई वन
D पहले D
चैनपुर थाना चैनपुर है परगना बरवे परगना नीचे में मौजा भी लिखा हुआ बरवे मौजा नंबर नाम में जर्दा नंबर
जर्दा
मौजा नंबर नाम में
अरे नाम
जर्दा
है
नंबर-
मौजा के बगल में थोड़ा ऊपर नीचे लिखा गया हाथ का 3 कॉलम है 3 नाम है
नहीं ठीक है वो
इसको आप समझेंगे आप तभी से कल से कह रहे हैं हम आई वाज कीपिंग टाइट आई हैव एग्जामिन्ड माय सेल्फ नॉट द रिकॉर्ड
देखा उनको दिखा
इनको
उनके
देते
पास सही है
है
ओरिजिनल
ना आपके पास
हम कल सप्लाई किए
अब जो कल से कह रहे हैं कि गलत ना
ये
अब जो
नहीं।
इसमें जमींदार का
एक
नाम
सेकंड।
देखा जाए
जमींदार का नाम देखा है शेख बहादुर अली
ठीक है D/1 D/2 देखिए आप
हाँ डी बाई टू भी देख लीजिए शेख बहादुर अली के
अब आ रहा
डी बाई वन है
D/1 D/2 भी
डी बाई टू एग्जिबिट 5 है सेम है दोनों का वही तो हम दिखाना चाहिए एग्जिबिट 5 महाराज प्रताप सहदेव के नाम से
वो दोनों क्यों दिए हैं हम एक्सप्लेन करेंगे अब उसके बाद
जर्दा
हम
तो
प्लेन
है इसमें लिखा हुआ
सब जगह जर्दा
हाँ एग्जिबिट वही जनरल
हम आई एम नॉट हियर टू मिसगाइड पीपल
नो
देखिए खतियान
आई
तो
एम
आप
नॉट हियर टू मिसगाइड
आप नॉविश तो नहीं है ना खतियान तो आप पहली बार नहीं देख रहे हैं, right? तो ऐसा नहीं बोलना चाहिए बाकी डिस्क्रिप्शन ऑफ प्रॉपर्टी सही खाता नंबर ये सब सही
हाँ
है
खतरा
उसके साथ पैरा 8 ऑफ द WS देखा जाएगा हम लिखे हैं कौन खाता से हम लोग का मतलब है और किसका कोरेस्पोंडेंट क्या है इनका प्लेंट देखा जाए प्लेंट इज साइलेंट
I will place
Yes,
everything,
yes,
sir.
please.
Let me submit my.
आई डोंट वांट टू वेस्ट द वैल्यूएबल टाइम ऑफ
No. Yes, Lordship, देखा जाए exhibit D and D by one
पहले
is
एग्जिबिट डी बताइए
हाँ exhibit D देखा जाए
चैनपुर बलवे
बारवे मौजा नंबर का है जर्दा नंबर 76
हाँ जर्दा नंबर
हाँ पर मौजा का नाम बारवे है और इसमें देखा जाए किसके नाम से
परगना बलवे मौजा का नाम परवे नहीं
इसमें नेम ऑफ लैंड होल्डर का नाम देखा जाए
इसमें 3 ही कॉलम है ना राइट जर्दा है
जर्दा नंबर 76 है मौजा का नाम बारवे
जर्दा नंबर 76 क्या होता है बताइए व्हाट इज जर्दा नंबर 76 ये थाना नंबर 76 आपके शेड्यूल में ही लिखा हुआ है 76 है ना नंबर 76
जर्दा नंबर
जर्दा नंबर लिखने से क्या होगा इट इज थाना नंबर 76 कॉरेस्पॉन्डिंग कॉलम में उस तरह से एंट्री नहीं किया
Yes, sir. इसमें लगाम पाने वाला नाम देखा जाए शेख बहादुर
हाँ
अली
लगान पाने वाले का नाम शेख बहादुर
शेख बहादुर अली एग्जिबिट ए देखा जाए डी या डी बाई वन में दोनों में सेम चीज है डी बाई टू कोरस्पॉन्डिंग टू एग्जिबिट 5 दोनों सेम है
D/2
और डी बाई टू जो है वो एग्जिबिट 5 है
आपने इसमें दिया है एग्जिबिट 5
हाँ एग्जिबिट 5 उनको दिए हैं, उनको भी दिए थे
ये जो लास्ट ये डॉक्यूमेंट है
हाँ हमारे मुंशी दे दी नहीं सर
एग्जिबिट 5 एग्जिबिट 5 क्या
एग्जिबिट 5 है रिकॉर्ड ऑफ राइट रिविजन सर्वे रिकॉर्ड ऑफ राइट इसके देखा जाए विलेज का नाम जर्डा है लगान पाने का नाम महाराणा प्रताप सहदेव है इनके नाम से हो रहा मंगरू कांसी और सोमा कांसी
ये जो ऑर्डर है R27 87 88
यस यस
एग्जिबिट 5
इसी पर हम ट्रेन कर रहे हैं सोमा कांसी के नाम पे रिकॉर्ड है सर्वे रिकॉर्ड ऑफ राइट में रिविजन सर्वे रिकॉर्ड ऑफ राइट में दोनों का नाम था, मगनू घासी और सोमा घासी।
But yes, you are the descendant of Soma Ghasi.
No, I am the purchaser.
Purchaser from whom?
हम क्लेम कर रहे सोमा घासी के बेटे कष्टू घासी और महारांग घासी से हम परचेस किए हैं 1.66 एकड़ लैंड इन द ईयर वाइट शेडेड एग्जिबिटेड 1 लॉट।
Exhibit 5 से आप क्या बताना चाहते हैं?
सोमा घासी से परचेस की एग्जिबिट 1 डेटेड 16/187 लॉट।
16/187.
यस
It is 23/388. Exhibit 5. वो तो आप सेलिब्रेट का डेट बता रहे हैं.
थोड़ा सा हल्का सा ब्रीफ जो फैक्ट है उसको थोड़ा सा क्लियर कर दें। जो टोटल लैंड है वो 9.78 एकड़ लैंड है आरएस खाता नंबर 39 में।
समीक्षी वो वाला जो भी हुआ है. अब बताइए.
यस टोटल आरएस खाता नंबर 39 में टोटल एरिया 9.78 एकड़ लॉट है। ये एडमिट
9.78
एकड़।
acre.
यस विलेज जरदा लॉट है। थाना डुमरी गुमला डिस्ट्रिक्ट गुमला है।
जरदा थाना.
थाना डुमरी पीएस डुमरी गुमला। आरएस रिकॉर्ड ऑफ राइट नेम इन मगनूम घासी और सोमा घासी के नाम से दर्ज है।
They are full brothers.
नो दे आर नॉट brothers।
Not brothers.
Yes. इसके हिसाब से आरएस से सर्वे ऑफ रिकॉर्ड ऑफ राइट के हिसाब से दोनों का बीच में हाफ दे आर इंटाइटल्ड ऑफ सिर्फ 4.89 एकड़ इंटाइटल्ड मगनू घासी थे 4.89 एकड़ सोमा घासी थे। अब मगनू घासी के 3 बेटी थी had 3 daughters of नीरो घासी के 3 बेटा थे पत्रू घासी who is different number 1 also and second son is खसरू घासी different number 2 also and third son is लसरू घासी who is different number 3 also। मगनू घासी की सेकंड डॉटर बीरो घासी BIRO बीरो घासी उनकी 3 बेटियां थी सॉरी 3 सन्स थे। रंगीला घासी वो डिफरेंट नंबर 4 डॉटर 4 इज पोंडा घासी 5 इज पोंडा घासी डिफरेंट नंबर 5 and different number 6 is फिरू घासी and different number 3 died issueless after marriage। now
Defendant number 3 died issueless. Lasru.
different number yes sir different number 3 died issueless not different number 3 no, the third daughter died issueless third daughter of Magnu Ghasi died issueless and so far the let's Soma Ghasi Lord Soma Ghasi had 2 sons Lord Kastu Ghasi which is different number 7 Lord and different number 8 is Maharang Ghasi। Now different number 7 and different number 8 proxy executed a sale deed in favor of the plaintiff proxy white sale deed number 126 dated 16/187 for 1.66 acre of land।
This is
exhibit 1। One important fact is Lord Kastu Ghasi's sons Lord namely Ranglal Ghasi who executed a sale deed in favor of Lasru Hasi, who is defendant number 3 lot. Right, sale deed 77/86 on 8/1/86 also. So defendant number 3 purchased the land lordship in the year 86, 8/1/86 lordship. We purchased the land in the year 87 lordship. And defendant purchased the land from my vendor's lordship. So he recognized my vendor as owner lordship. So after purchasing the land lordship,
So लिखें.
yes,
The counsel for the appellant has submitted that the property is relatable to RS Khata number 39, area 9.78 acres in village Jarda, Thana, Dhumri, district Kumla, which stood recorded in the name of Maglub Hasi and Somag Hasi. इसका स्पेलिंग जो है ना इम्प्रूव जजमेंट से देख लीजिए, मगलूब हसी एंड सोमाग हसी. Both of them were not related to each other, and accordingly each had a share to the extent of 4.89 acres. With respect to the genealogy of Maglub Hasi, he submits that he had 3 daughters, one died issueless, and the remaining 2 were Nero and Viro. Nero had 3 daughters,
3 sons.
3 sons, Patru, Khasru, and Lasru,
Defendant number 1 and 2.
who were defendant number 1, 2, and 3 respectively. Viro had 3 sons, who were defendant number 4, 5, and 6 respectively. So far as Somag Hasi is concerned, he had 2 sons, Kastu and
Maharang Hasi.
Maharang, who were defendant number 7 and 8. Defendant number 7 and 8 had executed sale deed to the extent of 1.66 acres wide, registered sale deed dated 6/1/1987 within bracket exhibit 1 to the extent of 1.66 acres in favor of the plaintiff. He submits that the title of the Maglub Hasi was the title of Somag Hasi was duly recognized by defendant number 3 earlier, when the son of defendant number 7 and grandson of Somag Hasi had executed a registered sale deed number 77 of 87
86. Dated 8/1/86.
Sale deed number 77 dated 8/1/86. This is exhibit
Exhibit 3.
exhibit 3. That's all.
Yes. Thereafter, plaintiffs filed an application for mutation of the land lordship, that is marked as exhibit 6 lordship. Mutation case number 47R 27/87/88 lordship.
And then mutation was allowed to the extent of
Extend to 0.90 and half decimal. 9.5 decimal receipt.
the learned counsel submits that pursuant to the registered sale deed, the plaintiffs had applied for mutation by the application as contained in exhibit 6, and the case was registered and numbered as mutation case number 47R27/8788, but the mutation was allowed partly to the extent of 0.90 and a half decimal.
Defendant number 1, 2, 3 also appeared in the mutation proceeding, Lordship.
In the mutation proceedings, the defendant number 1, 2 and 3 had also participated.
Yes, they raised the objection, Lordship.
They raised objection.
But the application was allowed for only 0.9 decimal, Lordship. Kindly see Exhibit 6, Lordship, because the yesterday might not seen the Exhibit 6, Lordship.
Why do we need to see Exhibit 6? उसके बाद तो सूट फाइल होगा. अब Exhibit 6 से
Exhibit 6 में वो पार्टीशन डिसाइड कर दिए.
ये Exhibit 5 है ना कि Exhibit 6 है?
Exhibit 6 ये Exhibit 5 तो ये होगा मेरा.
क्या?
Record of revision RS record of right.
अच्छा RS record.
RS
Exhibit
record.
6, right?
Exhibit 6 में वो पार्टीशन डिसाइड कर दिए.
हाँ, ये जो was allowed to the extent of 90.5 decimal by Exhibit 6 dated 28/3/88.
The circuit officer decided the partition.
He submits that the circle officer virtually decided the partition suit.
So against this order, Lordship, plaintiff instituted title suit before.
And thereafter the title suit was filed.
Yes.
इसमें क्या बताना चाहिए?
Kindly see the judgment passed in title suit.
अब आप बस जजमेंट में थोड़ा फाइंडिंग दिखाइए, उसके बाद सीधे सब्सटेंशियल क्वेश्चन ऑफ लॉ करेंगे.
Yes, yes.
ट्राई को
एक fact against the said deed was against the said deed, Lordship. Defendant never challenged the said deed before the any competent court of civil jurisdiction, Lordship. And so far as the municipal proceeding is concerned, Lordship, that also attains finality because as per section 87, Lordship, they have not filed any suit before the revenue officer. 87 of the CNT Act. They have not challenged the order passing
The
municipal
learned
proceeding.
counsel has submitted that the sale deed executed in favor of the plaintiffs were never challenged
Before any competent court of civil
before
jurisdiction.
any competent court of civil jurisdiction, and he has also submitted that the entry in record of rights, that is RS record, has attained finality, which was never challenged
challenged.
by the defendants
By the defendant.
under any proceedings.
Yes, Lord.
But then,
The learned trial court, Lordship, raised one thing, Lordship. Defendant also raised one thing, Lordship. There is no relationship between Magnu Ghasi and Soma Ghasi, Lordship.
that you have already said.
Yes, so far the relationship is concerned, Lordship. That is not their legal requirement, Lordship. For norms to be recorded to get her in the several record of right, Lordship. Several judgment has been passed by.
Relation is not required.
Relationship is not required, Lordship.
उसके लिए क्या है, ऐसा कोई adverse finding दिया है क्या? Because they are not relation.
Yes, Lordship. They are also the learned, both the court, Lordship, declared my said deed is illegal, Lordship. There is, because they have not filed any appeal, Lordship, against the said deed, Lordship. They have not filed any suit, Lordship, for cancellation of my said deed, Lordship. And both the learned court declared my said deed as illegal and void.
In the present case also, the sale deed was not under challenge.
No,
That
no,
was your sale deed. They never filed it.
but both the court declared null and void, Lordship.
Your sale deed.
My said deed, Lordship. And no issue was framed for the same.
The learned counsel has submitted that the sale deed of the plaintiff has been declared null and void
Yes, sir.
by both the
Declared
courts.
illegal, Lordship.
Has been declared illegal by both the courts, although the same was not challenged
Yes, no.
in any proceeding,
In
and
any-
certainly the plaintiff would not have challenged the same. आप खुद तो नहीं चैलेंज करते ना अपना sale deed.
आपने से देखा
चलिए. अब issue 3. अब आप सीधे
Yes,
क्वेश्चन
kindly
ऑफ लॉ में
issue-
आइए ना.
the issue framed by the
अब क्वेश्चन ऑफ लॉ में आइए.
So,
Issue number 3 and 4 is relevant.
yes, Lord. Issue framed by the issue number 3 and 4 is important. Has the Soma Mandi name has been erroneously recorded during RS operation of inspector of equals and that is not clear. Has the plaintiff got title interest over Schedule A land and has defendant got any title and interest left irrespective of land described in the Schedule B of the claim? And next, issue number 5 is also important. Is the registered deed of sale dated 16/1/87 executed in favor of the plaintiff valid and legal?
The learned counsel submits that out of the 7 issues framed by the learned trial court, issue number 3, 4 and 5 are relevant for the purposes of this case, which are quoted as under.
Kindly see finding given by the learned trial court. So far as issue number 3 is concerned, see para 5 the trial court judgment. This is very important issue which is required to be adjudicated upon in the plaint or evidence. The plaintiff has tried to show any relations between the two recorded tenant Magnu Ghasi and Soma Ghasi. Irrespective of RS Khata number 39, the plaintiff neither pleads Soma to have any relations with Magnu Ghasi nor any genealogy or explanation is given to substantiate as to how the entry of Soma names in RS Khatyan Exhibit 5 having half share in the khata was made in his defendant. On the other hand, tried to explain in the WS that RS khata number 39 corresponding to CS khata number 37 which is in exclusive name of Magnu Ghasi, son of Lepa Ghasi. In support of this contention, the defendant has filed the RS Khatyan Exhibit D/2 and CS Khatyan Exhibit D and D/1. Exhibit D and D/1 shows that the CS khata number 37 is recorded exclusively in the name of Magnu Ghasi. The defendant has also filed the two village map of the Mauja Jarda prepared on the basis of CS and RS operation, which has been marked Exhibit E/1 and E respectively. On close comparison of the situation of the suit and in CS Exhibit E and RS map Exhibit E/1 coupled with the two survey Khatyan as aforesaid marked Exhibit D and D/2 conclusively establish the fact that the suit plot of RS khata number 39 has been carved out from the CS plot of corresponding CS khata number 37. So this is my submission that is wrong finding. Exclusively recorded in the name of Magnu
ये
Ghasi.
corresponding पे तो कुछ आप कर देते. How is it wrong finding?
क्योंकि
That is not the substantial question of the
सबसे पहले exhibit
नहीं ऐसे नहीं होगा. This finding is staring at you and there is no substantial question of this. That this exhibit D and D/2 established that plot in khata number 39 is carved out from the CS khata number 37. इसमें तो कोई dispute नहीं आप कर सकते.
बस थोड़ी कि the landlord name is different. Exclusively recorded in the name of Magnu Ghasi. The defendant has also filed the rent receipt granted by the ex-landlord marked Exhibit A series in which there are several rent receipts issued in the name of Magnu Ghasi.
एक सेकंड CS कब हुआ था 1908 राइट
Yes.
1905 RS कब हुआ था
RS में आया हुआ 32 1932-34.
तो जरूरी है कि सेम लैंडलॉर्ड रहे
नहीं इससे दिखलाना चाह रहे हैं.
कोई जरूरी है कि सेम लैंडलॉर्ड रहेगा
नहीं एक नाम है राणा प्रताप सहदेव के नाम से. एक है मोहम्मद
तो क्या हो गया उससे
रहमत अली के नाम. जो एग्जिबिट ए दिखा रहे हैं जमींदारी रसीद वो महाराजा प्रताप सहदेव का है. जो सीएस रिकॉर्ड ऑफ राइट दिखा रहे
जरी रसीद कब का है RS के पहले का है कि RS के बाद
हैं सीएस
RS के पहले का है कि RS के बाद का है
एग्जिबिट ए सीरीज.
RS के बाद का है ना
14/2/26 जारी करने की तिथि 14/2/26.
RS के पहले CS के बाद RS के पहले इसलिए खान
CS में खान थे,
तो इसीलिए वो
मतलब
ठीक है।
बहादुर अली।
अब 35
इसीलिए
में आए
वो-
महाराणा प्रताप।
ये बात में आए 32 में।
CS में महाराज प्रताप CS में महाराज प्रताप
नहीं,
देखा जाए।
RS में थे महाराणा प्रताप।
RS हुआ 35 में, 34-35 में या 32 में।
CS में तो थे बहादुर अली।
CS में दिखा रहे हैं शेख बहादुर, वही कंट्रेडी हो रहा है।
CS
नहीं,
तो होगा
कॉन्ट्रेडी नहीं हो रहा है कुछ, थोड़ा कंफ्यूज मत रहिए। D and D by 1 is CS,
यस सर,
CS is बहादुर अली,
शेख बहादुर अली।
right?
यस सर।
Your rent receipts are of the year?
26।
रेट
जमींदारी rent receipt.
हाँ, जमींदारी रेंट रिसीट
26,
जमींदारी, हाँ एग्जिबिट ए है 26 का, ये
26
महाराज प्रताप के नाम से।
महाराजा प्रताप।
महाराज प्रताप वही चीज दिखाना चाहते हैं। कोई हुक्मनामा में फाइल नहीं किया, नो जमींदारी रेंट।
पढ़ी।
Exclusively, page 5, exclusively recorded in the name of Makhdoom Ghasi, the defendant has also filed the rent receipt granted by the ex-landlord marked Exhibit A series, in which there are several rent receipts issued in the name of Makhdoom Ghasi in respect of suit Khata 39 showing payment of rent exclusively by recorded tenant Makhdoom Ghasi. The defendant has also filed the two state rent receipt in the name of Makhdoom showing payment of rent for the whole of the suit land by Makhdoom. इसमें आई पास करो DW7 जो रेट रिसीट जो एग्जिबिट करवाया है, वो अपने गवाही में बोले हैं कि इसमें ओवर राइटिंग है स्टेट रेट रिसीट में. He also admitted loss. Immediately after vesting of the state granted in the year 1956 and 58. Different number 7. He also admitted loss. Who has filed their written statement are different number 7 and 8 who has filed their written statement are sons of RS tenant Soma, who has not dared to participate in the trial nor either or then he has been examined on behalf of the plaintiff in the suit or there is any documentary or oral evidence produced by their on behalf of substantiate their claim of the title therein possession over the suit land either prior to the RS operation or subsequent to that. The defendant case is that recorded tenant Soma was working in the horse stable of the ex-landlord as a protector, which is supported by PW3 in his evidence in para 2, who has unequivocally stated that defendant number 7 has been living in a different village, namely Katimba, which is 2 posts away from the suit village. The other witnesses of the plaintiff also admit that Soma along with his son had left the village and has been living in another village. The recorded tenant Soma's name was never mentioned in the answer nor any rent receipt is being filed on behalf of the plaintiff to substantiate the claim of the possession of Soma or his sons defendant number 7 and 8. Even the plaintiff's witnesses does not speak about Soma's possession or possession of his 2 sons even after RS operation. Rather, there is a pleading and
Go to
evidence.
para 6.
Therefore, on the basis of documentary and oral evidence discussed here, it is found and here that Soma Ghasi's name was erroneously entered in the revisional record of right, and on record of such entry, no title was conferred upon him. As such, I am in this conclusion that entry of Soma Ghasi name in revisional survey in respect of suit Khata number 39 made Exhibit D by 2 and Exhibit 5 for the plaintiff is wrong and illegal, and Soma Ghasi of his sons defendant number 7 and 8 had or is absolutely no title or position in respect of suit Khata number 39. Accordingly, this issue stand decided against the plaintiff and in favor of the defendant. And see paragraph 7 also, beside issue number 4 and 5. The plaintiff has based the claim of his title and position of the registered deed of sale executed by defendant number 7 and 8, son of Soma Ghasi, which is dated 16/7/87, marked Exhibit 1. Here, Exhibit 2 is signature of PW2, Nicholas Tigga, made on the sale deed as an identifier. This witness PW2 admits in evidence in para 7 and 3 that he is friend and relation of the two plaintiffs and hence the most unreliable man instrumental in the whole episode of the transfer of the suit and in favor of the two plaintiffs. This man seems to be the creator who has unnecessarily dragged his plaintiffs in the purchase bid with a view to harass the defendants. Exhibit 3 is certified copy of sale deed executed by Langla Ghasi, son of Kastu Ghasi, defendant number 7 in favor of Lasru Ghasi. Condition defendant number 3 since deceased which is in respect of half area of suit plot number 273, 285 and 287, whereas the subsequent sale deed made in favor of the plaintiff by Kastu and Maharang is in respect of the whole area of the suit plot number 287, while the area of plot number 273 is half only out of total area 22 decimal. So these two sale deeds, exhibit 1 and exhibit 3 taken together goes to show that both are only paper transaction. None of the deed speaks about any partition between the two recorded tenants, nor defendant number 7 and 8 in their WS, which has been made exhibit 4 by the plaintiff, speaks about any partition between the two recorded tenants, or as to how the landlord had any right to execute such deed. Exhibit 3, which seems to have been purposely created. Exhibit 6 and 7 are the mutation order and correction slip passed in respect of half of the purchased land in favor of the plaintiff on the basis of RS survey entry made in the name of Soma. This order, Exhibit 6, also does not speak about the position of the two vendors Somas and Soma Ghasi and makes the Soma's name in RS on the basis of title, which I have already adjudicated to be wrong and illegal. None of the plaintiff's witnesses has spoken about the position of Soma or his sons over the suit lands. On the contrary, it is pleaded by the plaintiff that they are in possession for 20 years prior to the execution of their sale deed in their favor in the year 1987. But PWT 3 in his evidence speaks that plaintiff possession was up to 35 years in his evidence, but the plaintiff himself in his evidence does not speak of any such period, nor there is any paper to the effect. PW2 in his evidence, para 4 says that the talk of purchase was held in Moja Katimba in presence of his brother and Benjamin Tigga, but neither his brother nor Benjamin is examined in the suit, and the plaintiff himself in his evidence, para 6 says that the talk of purchase was made in his house at Moja, Jharkhand itself when the vendors came there in course of Bataika. Both these versions are contradictory to each other. The sale deed exhibit 1 with respect to whole plot without any partition, which has neither been pleaded by the defendant nor 7 and 8 WS, nor he has come in evidence as such has been executed by the two vendors only with a create a color of title which apparently the vendor of their father Soma Ghasi could not have get on account of such wrong entry adjudicated. Already the defendant on the other hand through his two survey khatya exhibit D and D by 1 rate receipts granted by X landlord and state of Bihar exhibit A and B series coupled with consistent statement of the villager examined as DW1, DW2, DW3, DW5 and DW6 has spoken about the claim of the title and possession of this contesting defendant since the time of their father Maghlub Ghasi. Therefore, on the basis of evidence, fact and reason discussed above, I find and hold that the plaintiff has got absolutely not claim of the title and possession of the respect of the suit land described in Civil A of the plaintiff, and the said deed exhibit 3 made in their favor is held to be void and illegal. Issues accordingly stand decided in favor of the defendants and against the plaintiff. So for issue numbers 1, 6 and 7.
See, in your plaint also you have not mentioned about the history of the property. You have also not mentioned who was the ex landlord, how these people they acquired the property. Nothing has been. You claimed only on the basis of record of rights. That was your claim, right?
Yes, plaintiff only since the mutation.
Yes, you say that the name of the landlord is different. You have not joined issues on that. Had you said that he was the landlord, then they would have responded that no, there was somebody else. Then it could have been adjudicated. You have not disclosed the name of the landlord in your plaint, nor they have disclosed the name of the landlord in their written statement. Now you are wanting me to enter into that document and figure out who is the landlord. You have not joined issues on that. And that was never your case before the court.
But the learned court, how can declare my said it as
Where is the declaration?
yes,
Learned
Say
court
no.
did not say.
yes,
The learned court has, it is just a consequential
Right.
relief. you said you just wanted a declaration of title on the basis of sale deed,
Yes.
right? The learned court says that your vendor has no title.
No
Simple.
possession, no title.
No, that is
That is a finding.
Can you see my plate box?
Where
Nothing
in
has been
possession,
said.
even your possession has not been mentioned.
Yes, can you see paragraph of my plate box?
Plain से क्या होगा? Finding दिखाइए.
हाँ, finding purpose possible. हम
Finding is
deposition.
purpose.
Yes,
It is
deposition आ गया.
purpose.
That is not the substance.
That is not the substantial question of law. Please, आप इतना seasoned हो गए, आप इस तरह समझते हैं.
नहीं पर
See, you are
deposition में आया हुआ जो कि हम लोग
just a moment.
we are in the position also.
आप कैसे ये second
आगे
appeal
बताया
कर
जाए।
सकते हैं? Plain and written statement में कोई जिक्र नहीं है जिस चीज का, उसको आप बहस कर रहे हैं.
प्रिंट
How
में
can-
भी नहीं
how
लिखा है
can
कि
this
आरएस
be
रिकॉर्डिंग के
agitated?
नाम से। प्रिंट में
कुछ
भी
भी
नहीं
नहीं।
लिखा उनका रिलेशन क्या है मंगरू से।
वही
The relation is not required.
Relation is
You
not
forget
required.
about it. Relation is not required.
Yes, ma'am.
But the point is that foundational pleading on the basis of which you are arguing the case,
थोड़ा
that somebody else was a landlord, दोनों में अलग अलग landlord लिखा है, इसे क्या होगा लिखा है?
This is not in the plate.
So you will argue whatever you want to.
एविडेंस बियॉन्ड प्लीडिंग
Because there is
Please don't.
No,
you
because
you see, I did patience hearing
Because-
because of the reason that there could be a gap in facts. But that does not mean you will argue anything you want to.
No, no, because their discrepancy is made as
The court has passed a clear order explaining, considering the evidences, that the discrepancy in CS record and RS record was there was no justification for entry of the name of Soma Ghasi, and he was not even in possession of the property.
See, the name of the Soma Ghasi lordship come in the revision survey of record of right. That is exhibit 5.
It is
lordship.
only a
That is
presumption.
Presumption. That is
That's right. It is just a presumption.
सब्जेक्ट टू rebuttal.
Yes.
So
We
they
have
have
rebutted.
yes. When they have rebutted lordship, they have not filed any application for cancellation of the my mutation order
Need
lordship.
not.
They
Need
have not. They have not challenged
They will not challenge the
Mutation does not
Mutation
create
does not.
right nor extinguishes.
Because
This
they have
is the
not
settled
challenged.
law.
They
It
have
is a
not.
rebuttable presumption,
Yes,
and
yes.
that stands rebutted. Simple.
But since they have not challenged my scheduled also blocking mutation order, that has not been challenged. So the RS record
You
of
see,
right.
you are not in possession of the property. They need not challenge your title. They
Yeah.
need not challenge your sale deed.
Yes, Kali.
You are claiming title on the basis of a sale deed, correct? And that sale deed has been found that your vendor did not have the title to sell it to you.
No, defendant number 8 also admitted lordship. We are in the position lordship. Kindly see.
उनके admission
No,
से क्या होगा?
no,
वो vendor है तो admit करेंगे ही ना?
नहीं, सर आपको प्लेस करने दीजिए आप.
हम देखिए आप जो इस तरह से जहाँ तहाँ अपना सेकंड अपील में लेके जा रहे हैं ना, utilize your time to put forward the material facts which are required based on the case of the parties.
The defendant number 8 who is defendant number 8 lordship, who is defendant number DW 8 lordship, who is defendant number 2 lordship, who said lordship, in paragraph 10 lordship, कस्तू महाराज को आधा ही बेचने का हक था, तो उसने ज्यादा बेच दिया. खाता नंबर 39 का आधा जमीन कितना होता नहीं कर सकता. वो एडमिट भी कर रहे हैं. who is defendant number 2 है, कस्तू घासी, वो एडमिट कर रहे हैं. अभी पैराग्राफ 5 में बोले कि जमींदार के घर सोमा घोट से ही इसका काम करता था. जमींदार क्या करते थे. पैरा 8 में बोलते हैं सोमा द्वारा नाम चढ़वाने की बात मुझे 30 साल पूर्व लगभग नाना ने बताया था. 30 साल पहले रिविजन सर्वे रिकॉर्ड ऑफ राइट मालूम हो गया था, लेकिन दे नेवर चैलेंज.
तो डिवीजन सर्वे ऑफ रिकॉर्ड ऑफ राइट में सोमा का नाम कैसे आया? हाउ? Because Soma and these two persons, they don't have a common ancestor, correct?
Yes, ma'am.
Then in the CS record there was only one person's name. How does the name of Soma enter? Is there any hukumnama in his name?
उसी में आया हुआ है कि वो उसके यहाँ घुड़सवार थे.
घुड़सवार थे तो नाम हो जाए.
काम करते थे.
तो क्या हो गया?
जमींदार के काम करते थे.
जमींदार के नाम करते काम
So
करते.
it was the duty, their duty lordship to challenge the RS record of right lordship.
They have not challenged it.
Yes, they have not challenged.
Right, they have not
They
challenged.
admit it means
And
that will
what-
prevail lordship. RS
That
record of
prevail means
because they have not challenged. so
prevail
the-
means what? Prevail means it will only be a presumption
Yes,
of
kindly.
correctness.
Yes, kindly. Last opinion lordship, I cited one judgment lordship passed by this honorable. Can you see 2003 volume 2 JHR page 708 Lordship. Paragraph 9. In the case of Dwarka,
But
as noticed above, the admitted fact is that the revision survey record of right was finally published in the year 1966, and the record of right in respect to the suit property was published in the name of the defendant. The question therefore that falls for consideration as to what will be the effect in law of the two different entries made in the two different survey settlement of record of right, namely cadastral survey and revision survey record of right. It is well settled that if there is conflict between the two entries in the record of right, then the latter records of the right will prevail. A similar question arose before the Supreme Court in the case of Sri Raja Durga to Singh of Soren of Koru and others versus AI 1963 Supreme Court 361, where their lordship held that when there is a conflict in two entries, it is the latter entry which must prevail. It was further observed that where new entry takes the place of the old one, there shall be a presumption of correctness of the new entry until and unless it is established to be wrong or substituted by another entry.
Certainly, it is only a presumption, nothing more.
So because they have never challenged lordship, so RSR record of right will prevail because they have never challenged the entry made in the RSR record of right, and they were aware of the same lordship.
But you had filed your case on the basis of entry made in the RS record of right. They had relied on the basis of CS record of right. You joined issue on that before the learned trial court. Appropriate issue was also framed, and then evidences were led, and the learned court found that this there is no basis of entry of the name of Soma Ghasi in the RS record of right. There is nothing to back that entry, and ultimately held that the sale deeds executed by sons of Soma Ghasi was not valid. The reason being that Soma Ghasi himself did not have the title over the property.
So Exhibit 3 is also, they have also accepted my ownership lordship. Exhibit 3 lordship, the son of defendant number 3 purchased the land from the Ranglal Ghasi lordship. The father of the Kastu, his father is Kastu Ghasi lordship. Defendant, they purchased the suit land from Kastu Ghasi lordship, Ranglal Ghasi lordship, who is the father. Sorry.
Estoppel plea कर रहे हैं.
They
Is
stopped
it a plea of estoppel?
No, because they admitted the ownership मेरे ownership को they are admitting lordship. Exhibit 3 जो है 886 को they purchased the land lordship. They purchased defendant number 3 purchased the land lordship from the defendant number 7 lordship. Defendant number 7 who is my vendor lordship. So they are accepting the ownership lordship. So there was a partition between the property between the two different party lordship, and we are also the purchaser lordship.
When was the partition done?
This has come in the trading lordship. It has come in the trading lordship.
Evidence का है partition वगैरह. आपके पास इस एंट्री के अलावा क्या एविडेंस है? इस एंट्री के अलावा आपके पास अपने टाइटल का क्या एविडेंस है? एग्जिबिट ए, करेक्ट? एग्जिबिट ए.
Exhibit entry send it to claim registered send it to claim 1 3 5 revision server record of right.
रजिस्टर्ड सेंटेड एग्जिबिट कौन सा है?
मेरा exhibit 5 है.
That is it, exhibit 5.
Exhibit 5 है. Registered sale date है exhibit 5. Sorry, exhibit 1 है. 1 है, 5 है RS record of right. 1 है.
Mr. Sani,
Only
it's
in 3 minutes we have concluded. Only 3 minutes. Now the plaint is the basis of this. The law is very clear. What is not needed, and that cannot
that we will not.
be. So any evidence beyond. Now one thing more. The 3 points which my learned friend has raised. That entry in the RS, there is no dispute that in CS record of right, only the name of the ancestor of the defendant number 1 and 2 was there. There is no doubt about it. No, this is an admitted position. And there is no doubt about the fact that in RS record of right, prepared in the year 1930 to 35, the name of 2 persons, Mamru Ghasi, our ancestor, and Soma Ghasi, the ancestor of their vendor is there. They have approached the court for declaration of right title interest. So it is the plaintiff who has to prove his case. He can succeed on his own leg. He cannot take the advantage of weakness of the defendant. Number two, a bare perusal of the plaint right from para 1 to 15, your lordship will not find anything what my learned friend is advancing argument. Whether the Mangru Ghasi and Soma Ghasi, how we got entry in the RS record of right, number one. Number two, whether there had been a partition amongst Mangru Ghasi and Soma Ghasi, whether the Soma Ghasi's son were in different number 7 and 8 were in possession having title. So therefore, the entry in the record of right is subject to rebuttal, and that rebuttal, by way of rebuttal, the defendants have brought on record sufficient evidence, oral and documentary, which my learned friend has read from para 7 and 8 of the trial court judgment. I am not adding anything. So, my lord, the learned, both the courts concurrently found that the vendor of the plaintiff had no title nor any possession, nor a whisper has been made by them the vendors were in possession, and therefore Soma Ghasi was in possession, and then after his death his sons were in possession, and they got their names mutated. They were paying rent to the ex-landlord and then to the state. This is their duty, and that is big gap. And only after purchase by Exhibit 1, he got his name mutated, and very curiously, he purchased 1.66 acre by registered sale deed Exhibit 1, but he mutation was only 90 and 90.5 decimal. So what about rest land? He didn't do anything. Now one thing more, if the mutation order was wrong, then no declaration has been sought for in the plaint that the declaration by the CO has committed wrong. Now my all arguments are covered by single judgment. Everything has been given in detail. 2023 Supreme Court, just para 11 to 18, your lordship may kindly see one line sentence. Para 11 says, it is treat law that revenue records are not documents of title. Para 12, relying upon judgment of the Supreme Court held, mutation in revenue records neither creates nor extinguishes title, nor does it have any presumptive value on title. All it does is entitle the person in whose favor mutation is done to pay the land revenue in question. It is further affirmed in case number such and such, where the court held mere mutation of records would not divest the owners of the land of their right, title and interest in the land. Then
Mr. Sani, it is not a matter of mutation.
No, he says that I am not challenging the mutation order. I know.
Forget, he is not saying that. He says that you have not challenged the RS record.
Then another entry in the therefore not para 11, revenue record are not documents of title. It is presumptive.
You need to raise.
Then para 21 and 23. Para 21 और 23 बस
सर
और इससे
आपका आर्गुमेंट हम सेकेंड हाफ में रिकॉर्ड करेंगे, पूरा जरूरी है।
ठीक नहीं है।